Yes, Mr. Das.
My lord, if you consent, I beg to mention item number 18 here also.
Item number?
18. I'm yet to receive the up-to-date instruction, your lordship. So I pray for
That PF dues
yes, your
matter.
lordship. Sir, can if we can receive after a week, I'll try to get
They are paying that amount,
that instruction. I don't. They were trying to get
10 lakhs each per
Yes,
month.
your lordship. I'm trying
They
to
might
get
have
instruction.
liquidated that amount by now.
As of now, I don't.
When we will have it on Friday?
Like after a week, next your lordship.
Monday.
Monday, your lordship.
On the prayer of Mr. Das, A. Das, Learned Counsel, appearing for the respondent, it's called a
Assam Tea Employees Provident Fund Organization.
or a respond number
226.
226. Prays that he be granted a week's time to receive instructions as to whether the dues, PF dues as payable in terms of the directions of this court by the petitioner has since been liquidated.
Yes, your lordship.
Full stop. Accordingly, list this matter again on
10.
10/6.
Yes.
Have that instruction, we can close
Yes,
it.
your lordship. Another item number 40.
14.
Yes, your lordship. 40. I've taken the consent of the other side.
This is
I'm behind making a prayer on
14.
behalf of 40, your lordship. I'm making a prayer on behalf of the NK Das, your lordship. He's suffering from back pain since day for yesterday.
what happened?
Back pain, severe back pain, your lordship.
Is otherwise fine.
I don't know if I'm unable to get
This is with regard to that NIT of oil,
ONGC, your lordship.
oil, and
Can it be after a week? I've taken the consent of the other side.
is there any, okay, we'll adjourn it.
Yes,
Is
sir.
there anything surviving in these petitions
As of
after
that
that
information, I
decision?
don't have a lordship. I'm only praying, making a mention.
When do you want it?
After a week, your lordship.
After 2 weeks, I will find a picture.
After a week? On the prayer made on behalf of the parties to the proceeding, list this matter again on Wednesday, 12th,
Well,
12/6. Have it, Mr. Bell, madam, you also see whether something is, because they have taken a policy decision. And it cannot be held that that policy decision is so arbitrary. Because they have their own requirements to have reached that decision. Otherwise, the whole atmosphere is being polluted. See, now they'll have to issue, they have only reduced it to 1:1. One bidder, one vehicle. See whether something is there.
I'll update Mr. Das, your lordship.
Oh.
Much obliged, your lordship.
We'll have it on Wednesday.
Obliged.
Wednesday given over. Baro.
Maybe
Yes.
Your lordship. Your lordship, I beg to mention for listing of an IA, your lordship. Obliged.
Milagin and Dingo.
Yeah, please, Your Lordship. I beg.
One thing. It is pertaining to which bench?
This bench, your lordship. Actually, your lordship has earlier passed order, your lordship. Some correction is required
Typographical.
typographically.
Yeah, please, Your Lordship. I beg to mention item number 20, my lord.
20.
Yes, my lord. And then matter become infectious, my lord.
Period is over. Settlement period is over. Okay. Ma'am, your name?
L. Burua.
L. Miss L. Borua, Learned Counsel for the petitioner, submits that the issue involved in the present proceeding requires no further pertain to the functioning of a country spirit shop, which was settled with the petitioner with effect from 2016 to 2019. Full stop. The settlement period being over, the present writ petition has been rendered infructuous. Full stop. Accordingly, the writ petition stands dismissed as being infructuous. Okay?
May I please, your lordship. Lordship, I beg to mention item number 39, my lord. I am appearing on behalf of the petitioner, my lord. I have taken the consent of the respondent, my lord, private respondent.
It is with regard to that. What is your instruction? You were supposed to receive some instruction. PWD route going.
PWD is supposed to do, sir. I have
No,
filed my
PWD was supposed to file a report,
report,
but I don't find
report,
any
yes.
report in the file.
that private road is.
Will not pass any adverse orders, but let's see what is there. You be here. Just remind me that I have said I will not pass any adverse orders. No.
If I may, my lord, I beg to mention item number 28, my lord.
Huh?
Item number 28.
You need not bow down. You should raise your voice.
I beg to mention item 28.
28.
Yes, my lord. My lord, the conducting counsel, Mr. G. Chaudhary, my lord, he had to go out of station for some urgent matter. My lord, his matter is in relation to the election matter of Mr. H.R. Chaudhary.
It is with regard to a functioning of Bricklins.
Yes, yes.
NGT has passed an order. You have not challenged that, right?
My
Anyway,
lord,
when is Mr. Chaudhary coming?
my lord, in a week.
We'll have it on Monday.
2 weeks, 2 weeks.
Monday.
Monday.
No, this matters, 19 matters, we'll not keep it. 19,
Okay, okay.
Monday.
Okay. Highly appreciate.
On the prayer made on behalf of Mr. G. Chaudhary, learned counsel appearing for the petitioner, lists this matter again on 10/6/2024.
May I please, sir? I beg to mention, my lord, item number 22, the
22,
22. The petitioner would not like to press this petition.
not press.
Yeah.
Rightly so,
I would like to withdraw this.
rightly so. You would have been in trouble.
Madam.
The statements that you have made does not correspond to the actions you have taken. And the subsequent rectified deed, it is made after the land was brought by one of the patadas from the person who missed out. Anyway, Mr.
It's not.
Huh?
It's not.
Item number 22,
20.
H not. Learned counsel appearing for the petitioner submits that he is under instructions from the petitioner not to press this matter any further. Full stop. Accordingly, the writ petition stands dismissed on withdrawal.
Obliged.
Wait, please, Your Lordship, I read to item number,
Inform the other side also.
Yes.
I read to item number 17 and 21, my lord. Both the
17,
and 21, my lord. Both the matter has become suspended,
you have got 3 lakhs.
my lord.
17 and
21, my lord.
Mr. M. Hussain, learned counsel appearing for the petitioner submits that the ex gratia amount as claimed by the petitioners in the present proceeding has already been released to the petitioners. Full stop. Accordingly, no further adjudication is called for in the matter. Also, in view of the said submission, the writ petition having been rendered infructuous, the same stands dismissed as being infructuous.
Obliged.
17 and
21, my lord.
same, Obode. You have got 3 lakhs.
Yes, sir. As per my instruction, my lord.
Fine, you have got it.
Obliged.
Today's daily course list, delivery of order item 1.
Your thing has just come on record today.
Actually, my lord, I was under impression that letter will be listed on 5th and I have to deposit on 3rd, my lord. That's why, my lord. I apologize for that.
No, it's okay, it's okay, it's okay, it's okay, it's okay. Is there something more?
Yes, Lordship,
Oh.
judgment, to judgment. We-
But that you were supposed to give me on that day itself. It was not there on record when I saw yesterday night. Miss A. Gayan, learning.
Continue, my lord.
Mr. S.C. Cal, assisted by Miss A. Gayan, appearing for the respondents, have placed on record their written arguments. Full stop. The learned counsel, Mr. N. Sharma, appearing for the N.K. Sharma, appearing for the petitioners, have also placed on record the judgments they would rely in support of their contentions. Full stop. In view of the above, Miriam kitty aibo? Wednesday. I'm making it type type poetry. List this matter again on 18/6/2024 for delivery of orders.
Before,
Hmm?
that, it's not inconvenient to your lordship.
Huh?
Before that, lordship, on that,
Before that.
on
Why?
Friday, lordship.
No, why, what is the problem? Mr. Das will not be here.
No, lordship.
He need not be here. It's only for delivery of orders. I've heard you. What is more left?
Deep lordship.
Order implement of party item 2.
Yes, Mr. Barbujari. Have you got the application?
My lord, no, my lord.
But I find that these people, when the respondents who have been now sought to be brought on, were not put to notice.
Not put to notice.
Then how can this be maintainable?
Because otherwise, my lord, in the main contempt application, I represent R2 and 3.
Hmm.
But from R2 and 3, none of the respondents are there on service as on today.
No, no, fine. They have brought the revenue disaster and principal secretary finance. But what I find is that they have not been put to notice. Without putting them to notice, how can we
Yes, absolutely.
hold that a contempt has been communicated? We'll have it after some time. So if you get hold of Mr. Sarania or somebody, busy man, he may be moving around. Get
Otherwise,
hold of him.
otherwise, if lordship pleases, let this matter come in the next week.
No, no, no. Today itself. Why again? Mr. Sarania is here.
Yeah.
We are waiting for you. We kept it aside. I don't dare to pass orders when you're not here. No? Mr. Sonia, one thing,
My lord.
you have not put the respondents here whom you seek to implement.
The
To notice.
opposite party as a respondent number,
No, 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 you have not put them to notice. You have to, our procedure is that you have to give them a notice. Let's see, this is the order which is,
before implement. Oh, my lord, sometimes, my lord. it is-
sometimes, other times, like, how
Because
can,
it is within the notice of the respondent authority.
how
my
can we presume this is contempt? Otherwise, there was no problem.
lord. Sometimes court passes order also, my lord, earlier, last two.
This
parties are-
court is
My lord,
Purana Zamana.
I appreciate, my lord.
You put them to notice, come back. We'll close this, we'll give you liberty. Put them to notice and come
My
back.
lord, then.
And one thing,
take with the my lord.
one thing.
Contempt.
Now that order that is being sought to be implemented, right?
My lord,
The direction is at page 22.
my lord.
Hmm? So they were supposed to carry out an inquiry, and if you find that you are eligible for that ex gratia, the 50,000 limit was fixed and you have to give.
Right.
They went upon appeal.
Right.
Appeal dismissed.
Right.
Now, why is the order not being complied with?
So, my lord, immediately communicated to the,
Will not do. Now, have you gone upon appeal? Supreme Court.
no, my lord, they are now seeking the, my lord, necessary advices, my lord, from the.
What, once the court has passed orders, what necessary advice? We'll have it on Monday. Get the Wednesday, we get the complaints. Because after the division bench order, what is left here?
Now contemplate. Review, my lord, we have instructions to that effect, either to file a review or to go for a, my lord, SLP, and we are prepared.
Okay, when was the division bench order?
My lord, that is.
Division bench order is of 14/3/2024.
Yes, no, thereafter we have.
14/4, 14/5. Now it will be 14/6, 3 months. State cannot, 3 months, why? If your decision-making process is that, why?
No, my lord, that is true, but at the same time, my lord, we also want to, my lord, pursue the matter, my lord, before the review court, my lord, or before the SLP. That is,
See, you have crossed over that period of time. 3 months old.
no,
the
that
period
is
gone
true,
by.
but my lord, it is not that, my lord, they are disobedient, my lord. It is not that. Lordship will kindly see, my lord.
If there is no compliance after the order passed on 14/3/24,
Then, my
today we are 3 months down the lane.
permit me, my lord, to place the instruction on record, my.
I don't want it. That instruction is for you. For me, it's my compliance of my order.
Yes. So therefore,
Why 3 months? You may take another year to arrive at a decision.
lordship is absolutely correct, my lord, but the difficulty is, my lord, once they implement, because now, my lord, then they have already retired.
Okay, technicalities left about. Heard Mr. M. Sarania, learned counsel for the petitioner. Also heard Mr. R. Barpujari, learned counsel appearing for the
Respondent number
respondents number.
2 and 3, my lord, in the main contempt petition.
Here opposite party number,
Here, my lord, I,
appearing for the respondent number 2 and 3 in the contempt application. So the present application has been instituted, praying for impleading the opposite parties number 1 and 2 as respondents number 10 and 11 in the connected content petition. Also, I peruse the the amendments made in the writ petition and find that the opposite parties number 1 and 2 are the officials who would now be required to take steps for implementation of the order of the directions, violation of which is alleged in the connected content application. Accordingly, I find that the opposite party number 1 and 2 are proper and necessary parties in the said contempt petition, and accordingly, the present interlocutory application is allowed, permitting the petitioners herein to implead the contemners, the opposite party number 1 and 2 as contemner number 10 and 11 in the connected contempt petition. Also, the interlocutory application stands disposed of. In view, in view of the order passed today in IAC number 1596, 2024. Nangita opposite party number 1 and 2 day. Page 3 plus. Gyanendra Devati Party and Samir Sinha. Are hereby impleaded as respondents number 10 and 11 in the present proceeding. Full stop. Petitioner to file an amended cost title within 2-3 working days from today. Full stop. On filing of the said amended cost title, steps be taken for issuance of notice upon the newly impleaded respondents number 10 and 11. Full stop. List this matter after 4 weeks, along with a report with regard to the status of compliance, with regard to the status of service upon the said respondents number 10 and 11. Full stop. On the next date fixed, Mr. R. Pujari shall place before this court the steps taken by the respondent authorities for compliance of the directions so issued by this court, while the order dated, judgment and order dated 16/7/2015 in WPC number 5324/2012. So you get some time, now do it. Whatever you want to do. Next time it comes before me, I'll be.
There is
Cannot
no-
be.
there is no way of it.
No way of-
In fact, not my submission.
I'll have that.
Admission item 3.
Yes, amounts paid.
My lord, we have filed the affidavit, my lord, with paragraph 5. That we have already paid, my lord.
And some amount is left out. You will pay him that also.
Not sure.
We'll dispose it of. None appears for the petitioner on call. Full stop. The present petition has been instituted by the petitioner, praying for a direction upon the respondent authorities for releasing to him an amount of rupees 10,47,242,50. B, the expenses involved, been the expenses incurred by the petitioner society towards transportation charges against Antyodaya Anna Yojana, page 13 or so. And Mukhyamantri Anna Suraksha Yojana. Remember scheme for transportation charges involved against transportation of articles under so and so from FCI godown of Lakhimpur district to the respective godowns of the Gaon Panchayat Samabay Samiti, namely Kamalabari Samabay Samiti Limited. Full stop. The The Deputy Commissioner, Lakhimpur, has filed affidavits in the matter and therein has contended that the amount so claimed by the petitioner, a part of the amount so claimed by the petitioner has already been released to the petitioner upon necessary processing being made. Full stop.
My lord,
The statements, the contentions as made in the said petition, the affidavit being relevant is extracted herein below. Page 51, A to A. So, in terms of the above contentions as made in the affidavit, as filed by the Deputy Commissioner, Lakhimpur, an amount of rupees 6,48,967 is due to the petitioner. Also, as on the date of filing the said petition. Also, in view of the above position and there being an admission that the dues payable to the petitioner have remained unpaid, this petition is disposed of, directing the Deputy Commissioner Lakhimpur, that is the respondent number 3, to examine the claim of the petitioner, and in the event it is found that any further amount which, and it is found that amounts are receivable by the petitioner against transportation charges under AAY and MMASY scheme, the same be so determined and released to the petitioner within a period of 4 months from the date of receipt of a certified copy of this order. Also, the petitioner for the above aforesaid, to facilitate the aforesaid exercise now required to be carried out by the Deputy Commissioner Lakhimpur shall furnish a certified copy of this order along with a representation making a claim for the amounts it is to receive from the respondent authorities on account of the transportation charges under the said 2 schemes. With the above observations and directions, the petition stands disposed of. Done?
my lord.
Hey.
As per one order, my lord, the petitioner was directed to produce his original license, original permission. So anyway, my lord.
You have admitted in your petition affidavit what 6 lakhs you are about to pay him. I have not gone because he is not there. I have not gone direction. Then why take this planner? You should not have filed that affidavit then.
Lordship,
Oh, her Miss U Das, Learned Council appearing for all the respond, all the respond.
Applies.
What likhiti bote?
Item 4 and 5.
What is this mess you are creating? Huh?
So there is a mess, my lord.
It's not a mess. It's a created mess.
And it's
Now
not-
tell me one thing. You had a scheme, some scheme, BUSU something. She was occupying a plot of land. You said, come out of that. You stay in that. I stayed in that area. I know that, that bridge, Marakali bridge. Stay there. Once you stay there, you build up that inside building.
Solapur.
Solapur, that main
Solapur.
building. You build it. Now, when the list was prepared, her name is at serial number 36. Right? Now, there is a list prior to that, wherein her name figures. The others are not there. Now, when you make an allotment, but you don't allot a flat to her. Somehow she gets an impression that B1F6 is mine. She goes and occupies it. Right? Now you allot it to the other petition. From where? Because that original scheme under which the petitioner in WPC number 5149, this other petitioner was not even there. She was staying in the other side of the bridge, that garage where you have constructed now. I'm not saying she will not be entitled. Give her also, but don't dislodge. They're disposing of.
There is a stay order, she is continuing there. There is a stay order, she is continuing in that particular.
That's why I said she'll continue, but with regard to Mr. Sharma's client, you make an exercise, give her a flat. Because see, in that, we'll not go into that.
Their flats are available. I think
That
there
you,
are
however you do,
64
because you are
flats are-
entitled to give them. You should give them. Because they are requirement. of a state.
If all the flats are.
Mr. Bora, these people are a necessity.
That's.
Without them, we cannot survive. It's because of them that we are surviving.
That's.
We can breathe freely in the roads. Now, if you don't take care of them, why will they take care of us?
That flat has to be available, my lord.
That is your headache. You do it. Yes, Mr. Sharma.
Yes, my claim is that your lordship, I am the allotment holder,
Allotment order has got no antecedents in your case.
but my.
But in her
entitlement-
case, there is an antecedent. So we are interfering with the allotment order made in your case. We'll allow her to continue. And you are not an employee also.
No, your
You are a
lordship,
wife of an employee.
I'm the employee,
You are also an employee. That is not there in your writ petition.
but your lordship, my.
In your writ
my
petition,
husband-
that is not mentioned.
Yes, your lordship, my husband was the employee and thereafter I have been given. I will place it on record.
No need. If you are an employee, fine, we will do it. We will make provision for that.
Yes, sir.
But insofar as this petitioner is concerned, she was there in that list, 36. All others have been given, she has not been given. So we will direct for her to be given. And thereafter, we will also make a specific direction in your case that interference apart, you should also be given a plot, a flat, wherever they have. We are not limiting it. Right? That will satisfy?
He may not get in Solapur or some other Ambari area.
Hey, wherever you want to, we want her to be given a flat, that's all.
Well.
Mr. B.K. Das. Mr. S. Bora. You are appearing for Mr. GMC.
GMC. no.
And you are Mr. Sharma, you are here as, you are a private respondent here in
No, no,
35149?
They have not made the response.
Okay, forget it.
I have filed a separate.
WPC 4691. 2018. And what were you doing? She was occupying that land from a long time. And you were also permitting her. Then you came up.
No, your lordship, we have raised an objection.
I know, I've seen that. M. Sharma. S-A-R-M-A, na?
TR.
S-H-A-R. And Mr. Bora.
For GMC.
You are also here in the second case?
Well.
Second case you are there as a respondent?
The number.
Nine, your lordship.
Disclose. IAS যদি আই গিয়ে discuss করবে। We'll direct,
Lordship.
this will be continued for Mr. Sharma's client. Give him, we'll give a time frame. You come back on contact.
Exercise to be made by the Commissioner GMC.
Commissioner, okay, done.
Item 6.
May I please your lordship?
You don't please me, where is your application?
Yes, lordship.
This will not continue like this.
Yes, lordship. I leave up to lordship because I could not contact my client. Even I had sent a letter, register post letter.
Another thing, Mr.
Yes, I can understand.
No, forget that. How is a mother-in-law a legal representative of the daughter-in-law? Husband is there. Why was the husband not before this court?
Husband at that relevant point of time was out of station. So child was being taken care of by the mother-in-law.
That will not give her a.
Yes, lordship.
I had a similar matter in Arunachal. And do you know what I did? I found it to be because the prayer was that compensation should go in the favor of the minor. But the mother-in-law had it. I just closed my eyes and I told the council, file an amended cost title. Ms. D. Ghosh, Learned Counsel for the petitioners has submitted that in spite of her best efforts, she could not convince, she has not received any response from the family of the petitioner who had expired during the pendency of the present proceedings for substituting her legal heirs in the present proceedings. Full stop. In view of this said position, there being none. In view of this said position and the petitioner no longer being alive, there is none to press the present proceedings, and accordingly, the present writ petition stands dismissed for non-prosecution. Can't help it.
I can understand. I tried twice. They are not responding.
What can you do?
Yes.
You have done your best, but again, I know it's a pro bono thing. Get this thing
But
in
the
some
death-
other form before this.
Yes, because this death.
This
was
issue
very
is very-
painful because I have gone through the entire.
This
record.
issue, Ms. Ghosh, that you have raised is a very relevant issue. I think you should get it back in some other form,
Yes, Lord.
because this is a need of the society now. Because if those schemes are not being implemented at the ground level, so we have to take steps, try to get it back.
Yes, Lord.
Because you have done a lot of work here, I know, but can't help it.
Yes, Lord.
Item 7 to 10.
Passport matter for timing or made to your lordship. Dr.
Hmm.
Sarafi is in leg in.
Hmm?
He's in legs your lordship.
Okay, fine.
Made to your-
We'll have it. We'll have, what is there? Nothing. Only thing where the sale has ended.
Hello.
If the sale is also that other part,
Hello.
we will dismiss the writ petition.
Hello.
But if the sale ends and this thing comes on, then this will be subject to the service tax, not the sale.
My lord, may I pray for listing this matter on any hearing day, my lord?
No, today itself. I am ready. You get Mr. Chaudhary.
My lord. Yes, your
I mean, yeah.
Item 11.
What is this petition, Mr. Dodo?
My lord.
What is this petition?
Well, I just come to know, my lord, because our name also not reflecting.
Forget it. She wants a delimitation of the Gaon Panchayat.
She cannot, my lord, like this.
She cannot, it's a government's headache.
Yes, yes.
None has appeared on behalf of the petitioner on call. On the last date of listing, that is on 3/12/2020 also, there was no appearance made on behalf of the petitioner. Accordingly, the writ petition stands dismissed for non-prosecution.
My name may be recorded. my lord.
Mr. S. Dutta, learned, Standing Council,
PNRD.
Panchayat and Rural Development, PNRD,
Yes, ma'am.
is present for the respondents.
Thank you, my lord.
Item 12.
Oblige, sir.
Yes, madam, any proceeding against you before the Foreigners Tribunal?
We could not establish any contact with the client.
Huh?
We could not establish any contact with the client. So there is no information whether the matter has been transferred to the tribunal or not.
We'll dispose it of. Your name? Your name?
D Bangshiari.
Huh?
D Bangshiari.
D?
Bangshiari.
Spelling?
BANGS.
Just write it down and give it to me.
I'll write it down. Lordship,
Third, Miss So-and-so, learned counsel appearing for the petitioner. And also Miss U Das, learned counsel representing the,
For my lord. Actually, I am for deputy commissioner, but the other state respondent.
representing the respondents number 2
Yes.
2
6
2
and
7. Huh?
4, I am not representing, my lord. Mr. AI Ali will appear, my lord. 3 and
2, 3, 2,
5, 6. 7.
5, 6 and 7. Mr. H. Ali appears for respondents number 3 and 4. Who is there for respondent number 1? You're a CGC, Mr. Burwa?
No,
You're not a CGC?
I'm for the state.
My lord can record Mr. Samrat SS.
Mr. S.S. Roy, learned counsel appears for the respondent number 1. Full stop. The petitioner, by way of instituting the present proceedings, has presented a challenge to being denoted as a D voter in the voters list, right, in the voters list from 1997 and thereafter. Full stop. The petitioner in the present proceedings has submitted that the authorities, after denoting him as a D voter, have not taken further steps for referring his case to the jurisdictional foreigners tribunal for determining as to whether the petitioner is a foreigner or not. Full stop. Also, Ms. U Das Learned Counsel appearing for the respondents have submitted that in view of the fact that the petitioner has been denoted as a D voter, comma, necessary steps would be taken for referring the case of the petitioner to the jurisdictional foreigners tribunal for determination as to whether he is a foreigner or not, comma, if such steps have not been so taken. Full stop. In this connection, Ms. Das has referred to the guidelines laid down by this court-wide order dated 19/2/19, passed in the case of Shama Uddin, SAYAMUDDIN versus Union of India, boxer, WPC number 91/2019, wherein the learned single judge, wherein a coordinate bench of this court had indicated the steps that were required to be taken in the matter. It is not in dispute that the said guidelines can be suitably followed in the present case as well. Also, in view of the submission made at the bar, the present writ petition is disposed of by granting to the petitioner 15 days time to produce a certified copy of this order to the Superintendent of Police Border, Udalguri District, along with a representation praying for forwarding the case of the petitioner to the jurisdictional foreigners tribunal. Full stop. The Superintendent of Police Border, Udalguri, on receipt of such application along from the petitioner along with a certified copy of this order, shall take appropriate steps for ensuring that within 30 days thereafter, a reference is made before the jurisdictional foreigners tribunal so as to determine the question of citizenship of the petitioner in accordance with law. With the above observations and direction, the writ petition stands disposed of. You get a certified copy within 15 days, give it to your client, let him appear within 15 days before the Superintendent of Police, rest the Superintendent of Police will do, right? You give your name in writing.
Item 13.
Last occasion, Lordship has directed us to give the details of the my lord beneficiary.
This is a matter of, my lord, compensation for extremist killing, man.
Mr. Nath, just show me
Lordship,
that your family
Lordship,
members
yeah.
were also killed on 17/5/96.
Lordship will find a list submitted by the, my lord.
That list we are
Gagapura.
not accepting because that there is no signature. That list at page 43,
Yes, my lord.
we are not accepting that.
Because, my lord, the SP, Lordship will find page 45 report of the SP. Here's case number, Lordship, 134 has been.
134, there has been a list
Yes, my lord.
wherein your names are not there. Because they have filed affidavits to them. And
Victims,
in that affidavit, they have denied.
yes.
My lord, that is separate case. And our case is 134. That is not 134.
134, come on, we'll see. 134.
134, Lordship is page 45. Page 45 means the SP's report is clear, my lord. That
This is item
that
number
record is not available.
13.
Dated Lordship 8 June 17.
Okay,
Annexure 8.
Annexure 8.
Yes, my lord.
Annexure 8. Here there is no signature. That is why this court, why an earlier order had refused to accept this.
Lordship, Superintendent of Police signature is there, my lord.
Where?
Superintendent of Police,
Where? Annex 8,
Annex 8, your lordship.
page 45. And the documents that you have here with regard to 13%, they have already been granted compensation.
No, my lord, that I have annexed the similar case, not my case.
I know that. Just show me that you are also a part or you were also involved in that. Your family members have expired. Where is that document to establish that?
Filed RTI so many times, that was not placed. My only prayer is that it should not be disposed of. with the
Will not do. We'll dismiss it because if you can't show whole petition I have scanned, there is no relation.
Because, my lord, I have filed additional affidavit. I'll file additional affidavit.
We will not
with the
permit you.
documents- with the
We will not
documents,
permit you. We will not permit you.
Because, my lord,
Mr. Nath, only problem here I am facing is that these are the relatives who were killed. You have filed an FIR which led to 134. There is no reference to your relatives' names there. Nothing.
relative's name is.
You
not
come to
there.
your FIR.
FIR lordship, yes, lordship.
Your FIR is at page
Page 28, my lord, 28,
28,
29.
26.
Yes, my lord, type
You come to the second paragraph.
yes, lord.
It is to be noted that has killed many people and some of them saved their lives. So and so, so and so. Where is the reference to that your relatives were killed?
That's why, my lord, we are running from pillar to post, my lord.
And
we are
that
not
FIR, that proceeding was
That proceeding
closed
was
as an
closed.
FR.
Yes, my lord. That is the reason. We filed RTI so many times. The circle officer and the DC.
You
did not-
withdraw this, I'll give you liberty. If you get better materials, come back.
Yes, my lord. I may be executed before the authority.
I'll not permit you. I'll only allow you to withdraw this. If you have better materials, come down.
No, my lord, my case, application is pending there.
We will not, in absence of a link between you and your case may be a genuine case, I'm not saying that. But once the government authorities have denied it, how can we?
Lordship, they are a very layman, my lord. They have no any document regarding
The-
it. They are, even the
Mr.
death
Nath,
certificate, death
Mr.
certificate.
Nath,
is not obtained.
Today in the list, there are around 6-7 cases pertaining to 16-5 and 17-5 incident
Yes, my lord.
from both sides, from both communities. If they have materials, why will you not have?
Then I will execute before the authority, my lord.
No.
I'll only, if you want to withdraw it, I'll give you a liberty to approach the authorities. That's all.
Lordship, that,
Mr. S. Nath, Learned Counsel for the petitioner. After arguing the matter at some length and on a query being made by this court to show the materials available on record, which would demonstrate that the relative so named by the petitioner had died in the violence that had occasioned on 17/5/1996, Ms. S. Nath has submitted that such clinching material are not available on record. Full stop. In view of the above position, Ms. Nath, S. Nath, Learned Counsel for the petitioner submits that he be permitted to withdraw the present writ petition and approach the authorities in the matter. Full stop. Prayer accepted. The writ petition stands dismissed with liberty to the petitioner to approach the authorities with cogent and relevant materials for redressal of his grievances.
I'm
Right.
for the 3 and 4 as well.
Ms. U. Das, Learned Counsel,
I'm for 2 law.
appears for the respondent's number
3 and 4, my lord.
3 and 4. Madam, you are for?
For respond number 2, lord.
Ms. T. Hazarika, who is there for 1?
One, my lord, person.
You appear, Miss
Person
Yuda-
of the department, my
Ms. U. Das
Ma'am.
appears for respond number 1,
Ma'am.
3 and 4. And Ms. T. Hazarika, Learned Counsel, Standing Counsel, Revenue and Disaster Management Department appears for respond number 2.
Item 14,
Yes.
And there, my lord.
Why are you not paying him?
My lord, that, because we have filed affidavit in my lord, that we have stated that, my lord, we have sent the proposal and all. We will have to, lordship, maybe please to pass.
You
order
have to,
appropriate,
you
my
have to pay him.
Lordship,
Your circular dated 13
my lord.
entitles him.
Four
And there is material on record which says that he has already received 1 lakh.
my lord, we have
The balance 2 lakhs pay him. You are HR Ahmed.
4 and 5, my lord, we have stated in our affidavit.
HR Ahmed. And Miss Yudas, you are appearing for?
My lord. My lord, for
One.
3, 4, 5 and 6. 1, my lord, disaster revenue, my.
3, 4, 5 and 6.
1, my lord, Hazarika will appear. 2, my lord, finance. This
3, 4
3, 3, 4, 5 and 6, my lord. And
and
appear.
T Hazarika for?
Respect number 1, lord. 1. 2, my lord, finance.
Mr. B Gugoi or anybody is here? A Solia, me Gugoi, R Purpujari.
My lord, he was here.
Dispose of.
My lord.
This item number 15 is also same.
Lordship.
14, 15, same day, disposed of.
Obliged.
Item 16.
অলপ পিছত আৰু মাতি দিব নহলে dismiss কৰিব।
Item 19.
Same thing.
Lordship.
না না এইটো খালি মই লিখি দিম ইয়াতে লিখি দিম। And you are appearing for?
4, my lord.
1, 3, 4, 5 and 6.
Yes, my lord. 1 is my lord, person of yes, I think.
Okay, fine, government only.
We have my lord.
And Ms. T Hazarika for respond number 2.
Yes, my lord. 18, 19.
Done?
Lordship. Lordship.
Disposed of.
Item 23.
What is here left?
My lord, only excuse my lord, second file, I have to take my lord.
অলপ পিছত মাতি দিম।
Second file.
Item 24 to 27.
My lord,
Hmm.
there are twofold disputes. There are 4 cases.
Hmm.
WPC 7457.
That is
of
the main one,
2018,
main
that is
society.
By us.
The others are the members.
Others are the members.
Members. Now,
No, my lord.
one thing, Mr. Just give me the other case. Mr. Diasu, 26 to Dioksu. Just a moment, Mr.
Yes, yes.
Just one prayer, I'm having a confusion there. Mr. Bishwas, if you can come to your prayer portion. Somehow I've not been made able to understand this prayer. Page 27. Huh? Accusation proceeding, page 27.
Yes, sir.
The land measuring, so and so issue accusation notices for the land measuring so and so 3 biga, 3 kata, 10 less after the land measuring 30 biga of land covered by so and so to the petitioner's hearing. To that extent, I understand, because you are say that you are also one of the members. Now the second, and or any other process, and or any other process of handing over possession of alternative land measuring 3 biga, so and so, this I did not understand.
To the petitioner's hearing and
To the respond number 7 is the petitioner, Mr. Chaudhary is representing.
Yes, sir.
Now, what is this prayer? And or any other process of handing over possession
No,
of
what is,
alternative area of land measuring so and so, so and
What has
so.
happened is there is a civil suit pending between us
Ah,
among, because the executive committee has changed. The allotment, they are trying to cancel our allotment.
you have gone before, filed a title suit there.
So,
And that is,
in the meantime,
that is pending.
The government has, under the Water Bodies Act, they have taken accusation. So we are not on the accusation part. But the thing is, the entire amount, if it is disbursed to the petitioner in the first case.
Has any amount been finalized?
Yes,
Then,
on the last occasion, amount has been a record of this. They had
Last occasion,
submitted before, I think it is in the record, your lordship.
so that is exactly the prayer that you made. Okay, fine. Yes,
And
Mr.
we have filed an application to affidavit in opposition today to an application filed by my learned senior.
For appropriate orders, you have filed an,
Yes,
I've got it.
And we have filed it today, the affidavit in opposition.
Wait, please. allow.
Now, what is the state, Mr.
Now, my lord, stage is, government is in the process of acquiring the land and it is at the very final stage.
Hmm,
Now, the dispute is regarding appropriation of the
Amounts.
acquisition compensation.
Hmm.
Now, my lord, their claim is that earlier body allotted them. Look, how that allotment, how can land be acquired in such a manner? By a deed of declaration? Who is the society to allot land? The government has allotted the land to the society
Why?
for construction of flats. Or basically for the members, construction.
Right.
Yes,
So you have, by that deeds of declaration,
yes.
which is there on record, you had allotted to each member 1 quota something,
No, that's
10
not-
losa.
no. Yes, it has been shown to have been done,
Hmm.
but it was done by a particular committee, executive committee of the time. By subsequent resolution, these have been withdrawn. This-
No, once the members have been given, whether it is permissible or if not, why should this code go into that?
Body didn't have the authority to, make allotment, then the subsequent body can.
No, no,
suggest-
no,
So
you
therefore,
can do it.
No, therefore, these are the disputes which are subject matter of the suit.
Huh.
So that is okay.
Okay.
So in title suit, it will be decided whether the allotment in their favor was correct or not.
So today, if you make a submission here,
Yes,
that the land that government is acquiring, let them acquire.
yes.
We
No,
can,
I
on-
think, my lord, regarding acquisition, nobody has any dispute. It
No,
appears.
it's only the appropriation of the amount.
Compensation.
We will say that the money that would be now due would be paid in terms of the decision of the title suit. Right?
Yes, your lord.
What more is required?
There is nothing more. Only this amount should be kept.
Will be kept in a escrow account, if I may call it. And then it will be apportioned in terms of the, is Mr. Chaudhary also a client, a party in that proceeding? The committee?
Subject to the outcome of
No,
the-
I am the society.
Now, you are also made a party, sure, naturally.
Naturally, naturally.
Naturally. We can dispose it of.
Oh, no. Only you. Any bit I have, you will have it over.
30 bigas,
Yes.
money ready.
Every time we-
One concern will be, we are concerned with the Patadala. If the society internally allotted some portion to somebody, that should not.
You are concerned with the society.
Yes.
How the society has dealt with its matter, that we will also cannot answer. That will be answered by the learned trial court.
Right.
What more is required?
Let them decide that matter of their own law. We have nothing to do with that.
Yes, Mr. Dhar.
Yes, ma'am.
Experts in this matter line.
Can I?
Dispute is pending before the
With the society and the.
We will say that amount that will be now, amount will be released by the government, but it will not be disbursed to the society or to the members. And the amount would now be decided in terms of the title. So you appear there. Make,
Not, with the,
পইচাটো ফাঁচি যাব পইচাটো ফাঁচি যাব পইচাটো ফাঁচি যাব
my lord, can this matter be called on Friday, my lord?
Oh, no.
Let us also have the instruction from.
you have it.
Tomorrow and day after tomorrow, I will not.
Please have your time. We want to resolve this.
Yes,
If this way we can do it,
yes.
I think everybody's interest is
Yes.
taken care of.
No, well, the only thing is, I think there is there possibly there could be an argument from our side. Whether at this stage, when the decision is yet to be taken, or my lord, perhaps what I will be arguing on Friday, subject to what your lordships may say, that this allotment may not confer any rights. Anyway, lordship will have it on Friday.
No, I would have said that if these title suits were not pending, because they have gone there to establish their rights, and there are some interim directions. There are some interim orders.
And
Affidavit,
my lord, what I would like to see, what were the terms of allotment to the society? Whether the society could have parted with the land, because it was allotment in favor of a composite society. It was not to any individual member. So therefore, whether. they
and
could
their
have parted
cases,
with that.
Mr. Chaudhary, we'll also have to then kindly factor in also on
No,
this.
My lord, to that extent, I will not argue.
No,
To
I'm
the
not on that.
extent of the,
I'm not on
extent of
that.
the money they have paid to the
That-
society,
No,
that will be refunded.
No, what they have said is that this land, when it was allotted to you, it was allotted at the rate that 60% of the land value you will pay as premium.
Yes.
And they say this 60% value you had collected from them.
No, that is their case.
Whatever it is,
No, what I'll be submitting is, to the extent of the money they have paid, they are entitled to that money, whether they are entitled to get the land.
that
is an
maybe
issue.
in this proceeding, this court may
Let me
not be
see, my
enough.
lord. Let me see what is the subject. of allotment
You address on that.
On Friday.
We'll see. Let it be on Monday.
Next Monday.
Monday. On the prayer of the learned council for the parties, list this matter again on 10/6/2020. If we can resolve it in that manner, why should
Possibly
we
Monday it can be resolved.
resolve it? Things are new for me, enjoying it.
29 and 30.
May I please, Your Lordship?
Yes.
One out here,
Hmm.
before going to this one, this affidavit is required from forest department. That question is involved. That Satajan Min Mahal, whether it is a bird sanctuary or not. That is why in the meantime, last of your Lord, Your Lordship, Perus, 18/7/2022. The affidavit is required. And moreover, my lord, I have contacted yesterday with my clients. That this particular bird sanctuary, now it has been, they may not do so because there is a market is been constructed now. Area, that is why affidavit is from forest department is very much essential, my lord. Because they are the authority to construct the bird sanctuary, if at all. That is main issue. And second issue is, my lord, if they want to go for bird sanctuary, they have given notice under section 3(1) of Land Acquisition Act 1964. But it's supposed to be as it is to be permanent nature. Therefore, that it should come under section 6. They don't the law point, it can be decided on law point, my lord. No separate affidavit. But first and foremost thing, it is to be ascertained whether they are going for furthermore for bird sanctuary or not. This is my humble prayer before Lordship today. Matter is a very old matter, 2003 onwards, it's going on same issue. Anyhow, my lord, if my learned friend files an affidavit, entire matter will be solved. Then
Your case is basically that this requisition or acquisition, what they are
yes, that
doing
was the
is not for the purpose which is
No,
highlighted
my
in 3(1).
Two meters are there, Miller, two meters are there, 29 and 30.
Hmm.
30 was I wanted to go for construction.
Hmm.
Then because as per.
Yes, Mr. Gogoi, what is your stand?
No, they should.
But
give us
our
affidavit.
prayer is against the chief secretary to implement the measures of the MPL. That, but my stand is something different, my lords, bit technical, my lord. Annexure 1 page 22, my lord.
Of
The writ petition number
313,
4925, my lord.
49,
25, my lord.
4925%.
This is society, my lord, the registered. Registered 2002,
Page?
22, my lord.
Hmm.
It shows the registration document, my lord, it had earlier not come to my notice yesterday. my lord.
2005.
Yes, but it has lapsed. It's gone, they can move this court.
Fine.
It's a
The other
technical issue.
petition is there.
Yes, ma'am. That petition I am not there, ma'am.
Huh?
That copy is not with me. Horan Dotto, Horan Dotto is.
Now they have changed their stand. They want to do pisciculture now.
Yes,
Fish rearing.
yes.
Good only for you.
Yes, but
Birds
our
will
report
get
is-
fish.
Our report is already there, my lords.
What?
Department, they have short, my lord, the forest department report of the annexure. Page annexure 13 of that society, that other one, 4.
Hmm. Or you mean to say that you don't want to have a bird sanctuary there?
We want to have, my lord.
But what is this then?
This is, has to be decided by the chief secretary. If he takes a call in the terms of the PI, my lord, this can be resolved, my lord.
Where is that PL order? Page 38 PL.
Yes, my lord.
Yes, my lord. 30th.
Oh, that PIL.
That-
Lives before any other bench without me.
Railway 29 figures. Actually, this lordship, this one, your lordship can.
It's still pending from that time.
Yeah, that is, my lord, that is. Now your last occasion.
Okay, we'll see. We'll see.
Yes, yes, my lord. Any other bench, my lord?
No, it was not by before me. Before me, Nantu Legedi, would it?
Hello.
29:30. I appeared.
Yes, your lordship, my lord.
I missed out on
Yes,
that.
yes, yes. Your lordship was called by your honorable chief justice that time.
31.
My lord, Mr. regarding.
Show me a conclusive material here that your husband was killed outside the forest area by the elephants.
My lord,
Husband's body was found within the forest area,
my lord. Yes,
right? If it is within the forest area, no compensation.
my lord.
You show me that your husband was killed outside the forest area. There is
My
no
lord,
material.
They use the word dead body is found and lying, my lord, not killed.
We can't sitting in a writ jurisdiction go and give a conclusion with regard to that. Can we?
My lord, his dead body is found and there's in the police report that his dead body was found, my lord.
I got it. It is there in the, you come to the affidavit file. Additional Deputy Commissioner. Hence compensation does not arise. You have not even countered that with material.
Have replied, my lord.
No, there is a Government of Assam notification office memorandum, page 26. Right?
Well.
Running page. That's an affidavit. Yes, Mr. Gugoi.
My lord, the state is very clear, my lord. He entered in the reserve forest and it was killed by the elephant, my lord. My lord, my lord, the verification can be done. So the police report goes otherwise, my lord.
Police report says it's here somewhere.
His body was found, my lord, they stated, my lord.
Where is that police report?
Yes, sir. Police report, sir. Page 10 and.
Page 10,
Ten.
police report. On so and so, so and so, so and so, so and so, so and
The
so.
police team went to the PO and found the dead body. They have not stated that he was killed inside the forest. They found, my lord. Court can drop
You show me.
as per evidence, my lord, court can draw presumption of facts.
Presumption should be based on some material. You'll have to show why you went to the forest.
My lord, to collect firewood, my lord, I have stated in my petition.
Have you been permitted to do that? Is there
My
any
lord, to
permission
collect
given?
nowhere in the forest, wildlife protection act or other, my lord, collecting of firewood is not illegal activity, my lord.
Then you run a risk. You run a risk. For that, the government cannot be asked to compensate.
My lord, and they have stated that he is entering the forest for collecting firewood. They also admitted
That is a
that-
statement made by you which they have reflected.
And they also stated that they supported the statement. And not only me, my lord, nearby all people had collected firewood.
Now, you come to page 26.
It's 36, chalo, koi na.
Page 27. You will have to get over with this. Page 27 of your writ petition itself.
Page 27 is our affidavit.
Your affidavit, okay, okay. Affidavit, yeah. 27. Running page 27. Affidavit of one additional deputy commissioner. Page 4 thereof. Yes, Mr. Gugoi, what can be done?
Well, normally, my lord, when elephant jumbos come out the area and
Then they kill, that's a different thing altogether.
I'm afraid, my lord, I have to resist, my lord.
Huh?
I'm afraid, my lord, I have to resist, my lord. It cannot be done, my lord. Because a poor person died, my lord, while elephant killing, my lord.
See,
In that locality, there is no fencing,
Mr.
my lord, no any precautions, my lord. That area is a reserve forest area, my lord. Nothing has been done, not even a forest guard there to divert the people entering the forest land, my lord.
If there is no one, you will enter.
No, my lord, there is no fencing also, my lord.
You should know about.
And they can control the wild elephants, my lord.
You agree that your
It is
body
a
was
severe
inside?
problem in the city also, my lord.
Any material other than that, Mr. Bora? Dora, any other material?
And my lord, I can file an additional affidavit, my lord, that
2021, what more additional affidavit will you file today? You have brought everything on record.
they have not debarred me and I am not involved in any illegal activities, my lord.
Who is alleging that you were involved in any illegal activity? Mr. Gogoi, you will be appearing for 1, 2, 3, 4 and 6. 4 and 4. 1, 2, 3, 4. Right?
Yes, my lord. What?
3 and 4.
3, 4.
5 is by Ms. Udas.
6
Six by finance, my.
video ka bana.
R. Borpujari.
And while elephant killed me, my lord, after raping me and came with me to the jungle, my lord. While I am fleeing away.
I know, but where is that material to show that you were picked up from the
My lord,
non-forest area and taken into the
regarding
jungle?
that, my lord, I want to therefore file an additional.
See,
application.
Mr. Dora, that will happen when the animals are going back. It will not happen when the animals are coming out. They will not kill somebody, take him back, an elephant coming out of the jungle. He'll kill somebody, then again go back to the jungle, keep the body there, and then go for searching for food. That is not the nature of elephants, unfortunately.
Therefore, my lord, court can presume, my lord. There is a presumption of threats, my lord. Doctor's postmortem report also stated that multiple fractures and injuries there and severe hemorrhage, my lord. PM report.
Okay, I'll permit you one thing. I'll hold that you are not entitled, but I'll permit you to approach the deputy commissioner. If you have any materials, satisfy the deputy commissioner because he is the authority.
But if you have any condition, already we have stated he is not.
If there is any other material other than this, I'll not block your thing. Go before the deputy commissioner,
And then
Make-
I can approach before the deputy commissioner by filing a representation.
representation.
That should be disposed of within the time frame. my lord.
That will not do. You approach with your materials, but it should be beyond what is there here.
Fine.
That I'll make an observation. Right? Disposed
My
of.
lord. And if, my lord, I can support it by witnesses, my lord, then I can give. them.
No, will not permit. You go before the civil court then. You withdraw this, go before the civil court.
My lord.
You go before the civil court, establish your right. Go
Either
before
to
the
the
civil
deputy
court.
commis- Either to the regulator or.
No, no, no. If you want to have witnesses, then civil court. Go before the civil court, establish this, get your money. We'll permit that. We'll permit that. 2 minutes. Otherwise, this will go nowhere. Because the factum of that death is not ascertained.
My lord, before the deputy commissioner approach, I can approach.
Then no witnesses. No witnesses. Will not permit you. Then I'll have to hold what is here and what I can permit you to now.
But they have stated dead body was found and lying.
You go before the civil court, adjust your right, do it.
My lord, in this
You
regard.
think over it.
Already 4 years.
Come after some time. Think over
Already
it.
4 years, my lord. Then in a civil suit, my lord, more than 4-5 years. My lord.
That we will. Otherwise, you're going nowhere, Mr. Dwara. You're not going nowhere.
If I entitle, my lord, then interest and all the.
Whatever is there, you will get it as per the civil court.
Public.
You think over it, or you withdraw this, I'll permit you.
I am thinking, my lord.
You
After 10
think,
minutes.
come back. Or you leave it to me, I'll dismiss it. Don't worry. No, time me.
Item 32.
Yeah, to the lordship. Having discussed, the two petitioners are vegetable vendors. They filed application for allotted.
You have not taken breakfast. You have taken breakfast. No. Then you have your lunch and come back. Loud voice.
Here in this petitioner on 3/1/2019 applied for allotment of 2 rooms.
Hmm.
That and submitted their application to the.
What is the
secretary.
stage of this thing now? Mr. Dotto? What has happened here?
Up to their instruction, I have to take, my lord.
Why?
What is happening?
You give a call. Have a phone call. Come back at 2.
My lord.
2 o'clock. There was an NIT
Yes.
to give him. He alleges that 7 and 8. Now, because of them, the NIT was cancelled. Get your instructions.
As admitted, my lord, that single tender was followed.
You get that?
Yes,
It's
yes.
not on record.
Yes, yes.
Get that instruction.
My lord, my lord,
And if possible, get a written instruction.
my lord,
We will have
my lord,
adjudicate. 2 o'clock.
my lord.
No.
Time being 7 to 10.
Mr. Saraf, there was a prayer made on behalf of the respondents that they want an adjournment. The only question here to be decided is whether that part, if I may call it the tail to the delivery of the vehicle, falls within the ambit of a sale or not. If it is within the ambit of sale, VAT will take over. If it is not a sale, it is an act like the registration of vehicles, insurance and all, then it will be service tax.
The section itself says that anything done before the delivery, delivery of the goods, before the sale. And after the sale, it is not included. And this is charged to service tax.
Just one doubt here, just something new for me. That's why I'm getting a clarification. Whereas registration of a vehicle, insurance, here the vehicle has to be transferred. The dealer will give it to the buyer and thereafter these steps would take place. Now, where is the point that the sale is complete in these cases?
Sale is complete when from the showroom, the vehicle is taken out.
Right. Now, normally, when the vehicle is taken out of the showroom, you say the sale is complete. But these acts that are involved here, ceremony, painting, chassis painting, these all happen before the delivery, in fact, occasions.
As you also know, that in the car nowadays, certain special reporting, etc. services are there, which are not in the sale.
Or do you mean to say, Mr., if I have not understood, that these are things which the dealer can do once the vehicle is handed over and then a demand is made.
And then only normally it is demand is met, but it is not compulsory that you will have to do it.
No, it's
And-
not compulsory.
If it's not compulsory, then the sale is complete and thereafter the services are there. Then I may give many services to the dealer, or the customer, like the taking, sending my driver to his residence to take it. The extra petrol, extra services, extra all of these are not. Because the
Within
duty-
that sale.
by the way, the duty is only that the car is in the showroom and the sale is complete, and thereafter whatever service you want, you can have the service. Like, assuming, I say, seat cover. Extra seat cover.
That will not come within the,
Now, if I provide the extra seat cover, that will not come. So there are various services, as we know, that which are not included in at the time of service. And once below the service tax is charged on the same,
how can you revert back to VAT?
there are judgments of the apex court.
I've seen it. You have given a compilation.
I think I've given a compulsion. And,
There was a compilation here.
and the written submission also I've given below. There
You are
is a
giving?
bit- In that first part below in the
No, it's not here.
Page
Written
one.
submission is not here.
page 1 to 20 below,
Of the new one.
my lord.
Okay.
You'll also may live with that first one. Page 1 to 20 is the written submission.
And their only plea is that the sale has not occasioned before these acts were done. In the affidavit, in one case, they have filed.
Now, the Delhi High Court also in the same case may held that
Yes,
the central legislation is the finance act. Once it is something is taxed under the central act, then the state cannot levy it. Similarly, the view has been taken by the Tripura High Court also.
Tripura High Court, wherein you appeared for the state.
Hello. And my lord,
You made the contrary argument.
and my lord, there are decisions of Bombay and other High Court where the various charges were charged for various services. And their court said that no, these are not chargeable to the VAT.
You
because
start
this is
from imagic creativity and then it flows.
by the- And other decisions will also the same view by different high courts.
Hmm.
That no, it will not come.
It's
within-
basically the decisions that you have given is basically with regard to that hire. Whether in a hire, the transfer of the goods occasion or not, to
Like
that
the-
extent.
Like the load charges in the one of the cases it was said,
Which
you-
case?
you'll also may just see one decision I will show to you also, my lord. This is a decision of the Bombay High Court. And it is, my lord,
That is that Segal Auto Riders.
my lord, Bombay High Court decision, it starts with relevant part I'm giving you also.
Hmm.
Just my lord. I know Bombay High Court decision. Bombay High Court decision, my lord, at page 60,
6-0
my lord,
of the new compilation.
new comparison,
Premier Automobiles. It's
My-
there here also.
my lord. Now, here
Yes,
you also see the
160.
I will take a lordship to in the head note itself. The quotation portion below. Held. That the service pool charges collected by the SSC from the distributor were not a part of the consideration for the vehicles sold to the distributors at all. The correct position that with you to establish and maintain the service promotion pool and participate in the benefit provided thereunder, the distributors had to pay certain amounts with the contribution, the balance amount required being contribution to the SSC, the collection of 10% was really a mode of collecting the contribution payable by the distribution and so on. And also we see the another decision of the Bombay High Court, which is also starts with at page 68,
Segal.
my lord, Segal. And 11 part, my lord, at page,
This is with regard to that registration and insurance.
my lord.
No dispute on that.
You also may just see, my lord, page 80,
80.
80, my lord.
Hmm.
There are 21.
I'm there.
In the present case, there is absolutely no reason to follow the finding of the tribunal that the goods which form the subject matter in the contract between the respondent and the buyer are in the specific and deliberate state. The transfer of property and goods pursuant to the sale, contract tax against the payment of the price of the goods. Delivery of goods is affected by sale to the buyer.
The obligation under the law to obtain registration of the motor vehicle is cast upon the buyer. The services of facilitating the registration of the vehicle, which is rendered by the seller SSC to the buyer, and in rendering that service, the seller acts as an agent of the buyer. The handling charges which are recovered and the respondent cannot therefore be regarded as forming part of the consideration payable to the respondent for the sale. Those charges cannot fall within the extended meaning of the application sale price, since they do not consider some charge by the so-and-so dealer.
Got it.
Well, also, in fact, the tribunal decision, although it is not, you should not place it whole or similar, but page 81.
Hmm. Para 8.
Well, pilot. In context of the definition of sale in section 230 of the Act, the sale cannot be completed unless the goods are ready for delivery. And everything necessary to be done in respect to the goods to make them in a deliverable state in accordance with the contract is complete. Only after that stage it is the question of the same being taking place can arise, and not prior thereto, since the seller cannot be said to have performed this part of the contract till then. The apportionment of the goods to the contract can take place only after the goods are complete in all respects according to the contract and are in delivery state. He correctly contended that the sale was complete when the issue of the sale certificate. He further submitted that the amounts reimbursed were paid by the services rendered by the petitioner for affecting insurance, payment of road taxes, registration charges, and the vehicle are not anything done in respect of the sale goods at the time or delivery thereof. All these activities are post-sale. They arise only after the sale is complete and not prior thereto. Section 230 of the Solution Sales Tax Act defines sale as the any transfer of property and goods for cash, deferred payment, or other sellable consideration, and includes any transfer otherwise than in pursuance to the contract of the property and goods for cash, deferred payment, or other valuable consideration, and any delivery of goods or had purchased as a system of payment by installment getting the vehicle insured so and so, so and so. Thereafter, referring to Milord, the various decisions, the tribunal
And
also-
here also the word delivery in our VAT Act is also not defined.
You also
Delivery
see
is
the-
defined.
No, delivery, Milord, you'll also see the section, Milord,
Hmm.
of the VAT Act.
Assam VAT Act. to this. Sale, gross sale is defined.
Two 34, my lord. Sale is at 243.
Hmm.
If you
Sir?
say the same book is there, then it will be paid.
Just
Written submission.
Assam goods, no, Assam VAT Act.
My lord,
Assam value added tax.
you'll also see, my lord,
Mr. Can you spare me a book? You have a book?
well, we should put the book on the question. Yes, sir.
Okay, sale. It all is grammatical and means every transfer. That's 1%.
40, my lord. 244.
244 sale price. Is the amount of valuable paid or payable to a dealer for any sale.
It's the paid or payable by
Made
dealer for the
including
sale,
the sum charged
including the
for
sum
anything.
charge or anything done by dealer in respect to goods at the
By
time
or-
of before delivery
of
of the
goods,
goods.
other than the cost of freight or delivery or the cost of installation in cases where cost is separately charged. And this is the language that they are trying to project in their writ petition.
Right.
that
No.
these are steps which you do before you deliver the vehicle.
So you'll also see, this is inclusive definition.
Hmm.
It says including anything done. Some charge for anything done by the dealer in respect of the goods
At the
at
time.
any time or before delivery of the goods.
Hmm. Other than the cost of freight or delivery or the cost
Then
of
if it
installation.
is separately charged, then it will not be included. If the freight and extra, if it is
That
separately
will
charged.
not be included.
But my lord, if the charges, and the most important thing is that my lord, once it is charged under the Finance Act, my lord, service tax.
No, that the question that they are raising is that you could not have gone before under the service tax. This should have been included in the sale price. So it will come under VAT. That is what they are trying to project.
I
Hmm.
understand.
Hmm.
But my lord, once it is charged under the service tax, the imaging as well as the Tripura High Court and the decisions, that you cannot, and Delhi High Court clearly said, my lord, that once it is charged under the Finance Act, then the same cannot be charged under the VAT Act.
And Delhi High Court, that case is a case wherein it was determined that this is service per se. And this does not have that your judgment in the earlier compilation, it was there. It does not add to the value so as to make it a sale price.
Now, the what?
But here the question before me, subject to correction, is that whether this part,
Will be
that
part of
tail,
the-
is also can be construed to be a part of the sale price.
Now you'll also see that what charges are for what services. In the services, what I'm rendering.
Hmm.
In the petition, my lord, in the written submission, if you'll also just see, my lord.
Of the Finance Act.
No, in the petition,
Ah,
written submission, page 3, my lord.
Hmm.
The petitioner is engaged in the sale of vehicles. In course of the business selling vehicles to customers, the petitioner charges certain amount on logistic handling charges. Such charges were on account of delivery ceremony, waxing, polishing of the vehicle after delivery, fuel given to the customer after delivery, driver cost for dropping the vehicle at customer's home, home visit of the sales personnel for post-sale follow, home visit by service advisor post-sales, and other handling costs, etc. So these are not prior to delivery.
I did not know. I thought these delivery ceremonies are all free. Now I see that it's also charged.
Delivery ceremony like giving the bouquet and this is the not chargeable.
Got it.
But the other ceremonies which are there, they give us a bouquet, they click a photograph and all those things, that is included. Nothing is charged. But after that is over, nothing is free.
I got it.
Tomorrow we
And this waxing and polishing you can do if your contention would be only when the vehicle comes to the buyer and the buyer requires that.
Otherwise, whatever is there in the showroom, it is already there, so not required. Nowadays, special waxing is there, my lord.
There is
so
a
that
coating given.
Scratch should not be there, and all those things. They are all charged subsequently, one may desire, one may not desire.
And these billings are done separately and the billing of the sale is done separately.
Right.
Or is it in the same bill?
No, my lord, because you have to pay the service tax on it.
Service tax, so you put it up in a different bill.
My lord.
Yes. Where is Mr. Chaudhary?
Legs, my lord.
When? Thursday?
My lord.
Mr. Saraf, I've got it. Let me also go through it once more. On Thursday, we will have it. Or you want it on a
No,
different?
at your lordship,
I've got your point. On Thursday, we'll go for a.
every judgment
Huh?
also. Your lordship will gone through the every judgment also.
No, no, just casually. Now I'll understand. After your this deliberation, I'll understand better.
Because nowadays, my lord, when the car is purchased, anything purchased, many things are done. Tomorrow I may ask for some TV there. I may ask for this one.
Sound system. Heard Mr. A.K. Saraf, Learned Senior Counsel, assisted by Mr. A. Borua, Learned Counsel, appearing for the petitioners. Same order, would I cite it? Mr.
H. Burwa, my lord.
H.
Borua.
Borua, Learned Counsel, appearing on behalf of Mr.
B. Chaudhary.
B. Chaudhary submits that the matter be taken up on when? Thursday?
My lord.
Fine, we'll finish it
My lord.
Thursday. On Thursday for final disposal.
Yeah.
Full stop. List this matter again on 6 6/2024 for final hearing.
Maybe mention a part, otherwise again it will, from this bench, they.
Thursday, it should come back to me. I don't think so. Within the week, they will remove me.
Happening, my lord. It is going here and there.
The matter, Enaka Likoksun, also, heard Mr. A.K. Saraf, Learned Counsel for the petitioner. So also heard Mr. H. Borua, Learned Counsel for the so-and-so. Mr. A.K. Saraf, Learned Senior Counsel, has made his submissions in the matter. However, the same remain inconclusive. Also considering the prayer made by Mr. H. Borua to have the matter listed again on Thursday, raised it to list this matters, so this item, Thursday as a part of matter.
My lord, I am obliged.
I'm sorry, maybe I have asked some irrelevant questions, but this was
No,
for
no, no.
understanding.
In fact, they are most relevant. I am obliged.
Time being 23.
Better become infrastructures. And let me be disclosed.
You said infractures, then no problem, I'm not dismissing it. Mr. L.K. Bora, Learned Counsel for the petition submits that the matter, that the issue involved in the present proceedings on account of lapse of time has since become infractious. Also, has been rendered infractious. Accordingly, the writ petition stands dismissed as having become infractious.
Time being 31.
Yes,
Highly representation before the issue.
okay, then I'll have to pass on. We'll pass on this.
To be considered on humanitarian ground, my lord.
That will not do, but then we'll have to, because the materials are not sufficient. We'll have to hold against you, but then I'll give you a liberty, but that liberty will be of no use to you. I'm telling you.
My lord, poor Marshapan died, my lord.
Then you withdraw and you go, withdraw and you go. I'll not make any observation. Withdraw and you go up here. I'll say that because of the stance taken by the respondents, you want to withdraw this petition to approach the Deputy Commissioner. I'll permit you that.
I would doing, my lord.
Mr. D. Dwara, R. Dwara, Learned Counsel for the petition after submitting matter for considerable period of time, given the dispute raised in the matter by the respondents by filing affidavits, submits that he be permitted to withdraw the present petition to approach the Deputy Commissioner by the jurisdictional Deputy Commissioner for raising his, for redressal of his grievances. Stop. By bringing on record better particulars pertaining to the death of her husband. Stop. Prayer accepted, writ petition stands dismissed on withdrawal with liberty as prayed for.
Yes.
Now you go. You can go and approach.
Obliged.
Mr. Chaudhary, you are waiting for what? Huh? 40, coming to that.
33.
Joymala. Iban itu?
33.
What's up? The Learned Counsel appearing for the petitioners has filed an affidavit wherein she has stated that she would no longer pursue the matter. She would no longer be appearing in the matter for the petitioners. Also, on perusal of the said affidavit, it is seen that the engaged counsel had issued notices to the petitioners highlighting that she would withdraw from the present proceedings, withdraw her wakalatnama from the present proceedings. Also, the said affidavit was filed on 4/10/2023. Also, the petitioner has none appears for the petitioner in the matter on call. Also, in view of the above position, there being none plus the present proceedings, the same stands dismissed for default. Also, Mr.
And Goswami.
Goswami and Goswami Learned Council.
One,
For
six,
the
and 7. 1, 6, and 7.
1, 6 and 7. Madam,
A. Longcomer on behalf of Mr. Arthur correspondent funds.
just write it down. Ms. T. Hazarika for 2, 3 and 4. And Madam on Namtu Bebe. Yep.
34.
The matter relating to my lord victim compensation.
COVID,
But the victim compensation.
COVID death.
My lord, yes. But here we have challenged the input.
Okay, victim compensation.
Yes, my lord. But we have.
Yes, Mr. Goswami.
Civil lordship.
Huh?
I will be allowed to file a civil lordship.
We have challenged the.
How come the district judge has entertained this application of yours? Because the procedure says if the district legal services authority rejects your case, you have to come before the state here.
Yes.
How come this?
But we have challenged the clause 7 of the notification itself, my lord, because my lord, 357 has no, 357.
Oh,
is-
yes, you have
has
challenged
not
clause
provided
7,
any
yes.
limitation, my lord.
Yes, you have challenged
But,
clause.
DLF
Limitation.
Yes, my lord. We
But
have,
that limitation power, Mr. Goswami,
yes,
is again hedged with the condonation power.
Look,
yes.
But in your application, you have not said anything about the delay. Okay, you have your instructions.
Lord.
Mr. When next week, Wednesday, Thursday?
Thursday.
Mr. N. Goswami, Learned Council. You are additional senior government,
No, I'm junior government. Junior government.
junior government advocate appearing for the state respondent submit that he be given a week's time to receive his instructions in them. Also, list this matter again on 19/6/2024, by which date Mr. Goswami shall complete his instructions. Let's see what we can do for you.
35.
My lord, item 36 also similar, my lord. 36.
We'll come to that.
My lord.
We'll come to that. Let us come to that. 30?
May I please the lordship? Lordship, item number 35, my senior is on lakes in court number 2. Kindly after some time.
May, I am on behalf of the respondent number 4, 5, and 6.
Hmm.
The matter relates to the enforcement of private road, public road.
That iron gate.
Yes, my lord.
Hmm.
Your lordships may kindly peruse the affidavit filed by the circle officer.
She is having some problem. We'll have it on a different day.
After some.
Your name?
R. Dev.
R. Dev, Learned Council appearing for the petitioner. This is item number
35.
35.
Lordship, add
Your
to-
lordships,
Submits that the matter be taken up on any other date on account of some inconvenience on behalf of the arguing council. Full stop. Prayer is not objected to by the councils appearing for the respondents. List this matter again on 18/6.
your lordships, we are facing great trouble for approaching.
Nothing much. Nothing much is.
Much obliged.
Your blessed.
36.
Here also, my lord, we have challenged the clause 7 as well as the input order passed by the DLF.
Now, in this writ petition, you have given up prayers 1, 2, and 4,
Yes.
right?
1, 2, 3.
1, 2, and 4. You have given up. There is an order.
1 and 2, my lord.
No, you have given up all. You come to order dated 1/8/22. Mr. Hussain Learned submitted that out of the 4 prayers, the petitioner does not want to pursue the prayers number 1, 2, and 4 at this stage with liberty to pursue the same at later point of time by approaching the court by another petition.
Lord,
Now only 3 is left.
My lord, we have also challenged the clause 7 also, my lord. Yeah. Because,
It's given up. How can I entertain? It's recorded here.
yes,
Order dated 1/8/22.
my lord, that may be by mistake or.
Now, Now this missing is of 2013,
Yes,
right?
yes,
Presumption 7 years, dead.
yes.
Go and get that drawn. What is, how can this prayer number 3 be now entertained?
Because, my lord, in the meantime, the police has.
He has
submitted-
to, there has to be a finding by an authority that he is no longer alive.
Because the final report already submitted,
Then FR submitted.
FR submitted, my lord.
Nothing
What?
survives here in this.
Sorry, my lord,
1, 2 and 4 prayers already deleted. That you will come back in a fresh writ petition. Come back. It's already there.
my lord, I have to go through the record, my lord, because, my lord,
A record to track. We'll have it after some time. Otherwise, we are closing the writ petition with reiterating that liberty to you.
it's-
Because prayer number 3, how can I direct them to produce when you are not to be found anywhere?
yes, my lord.
Then. ठीक है sir. Every time.
37.
I'm going to file the reply against the affidavit filed by the,
You forget it. Show me from the materials that the death was on account of a flood. The daughter died, unfortunately, falling in your own. Falling in your own pond. How can the state compensate that for for you?
because, my lord, the affidavit filed by the respondent number 6, my lord,
Hmm. Respond number 7.
my lord, respondent number 6.
Hmm.
Respondent number 5, my lord. Page 69.
Hmm. 60?
9.
Hmm.
Athani Revenue Circle, my lord. A drowning case occurred on 21/7/20 at so one site namely so. Age 4 years, daughter of so. Found near home at River Tipkai. The dead body was recovered on the same day by the local people. But in the,
The case is accidental, not due to flood.
yes, accidental.
Then?
But similarly situated matter, my lord, already disposed of by this honorable court, my lord. That is why we are going to file the reply, my lord.
Show me.
We have got the same on record, my lord. But we could not file because, my lord, we could not serve.
Where is that similar order?
Similar
Rafiqul
one,
Islam.
my lord, in the affidavit, page 80, it started from page 80. In this case, 2 persons are accident. Secondly, my lord, direction was given to pay compensation under notification 15/11/2014, my lord. Since the matter is accidental, my lord. Last.
But in this case, there was government had itself admitted that we are paying.
My lord,
In this Rafiqul's case, that
Yes.
case that you are relying on,
yes, my lord.
Rafiqul Islam, the government itself admitted that we will pay.
Accidental, my lord. In this case also, the government admitted that, my lord, the matter is accidental. In the report, my lord, only, my lord.
Yes, Mr. Goswami, what do you say?
Decline is, my lord, this is not a private, this is a private place, my lord. This is the statement of the,
In this case, we have also filed an affidavit, Lord.
Hmm.
Lordship may page 69. Yes,
69.
Yes, Lordship, Annexure C, our
Hmm.
affidavit. The flood, daily flood report, Lordship, from
Hmm.
Assam State Disaster Management Authority.
Hmm,
In page 69,
hmm.
Lordship, it has been clearly written that the dead body, that, this case is accidental, not due to flood, Lordship. Body has been recovered from the, local, persons from Tipka in.
Where is that scheme?
Scheme, my lord, I have annexed in the reply, my
Wait,
lord,
wait. Huh?
1511.
In this reply,
Yes, my lord.
you have filed this.
Not yet filed, my lord.
Why?
Because, my lord, we could not serve copy to the assistant.
Huh?
We could not.
You file it, we'll have it day after. We file it,
Yes, sir.
we'll have it day after. Mr. M. Hussain Lamek, counsel for the petitioner submits that a reply as filed by the petitioner against the affidavit in opposition filed by the respondent number 5 would be filed during the course of the day. So accordingly, the registry to list this matter again on seven, good idea, 7/6/2024, Friday. And just examine whether if it is an accidental death during flood time, whether it will also be covered under that. Hmm? Just examine.
38.
What is left here? 2018, 5 years gone.
Influx of.
None appears for the petitioner on call. It is seen that the matter pertains to a no confidence motion initiated against the petitioner hearing. Also, the petitioner was elected as a president was elected as as president of 16 number Joyanagar Gaon Panchayat in the year 2018. Full stop. With the flux of time, the tenure of the petitioner has also stood completed. Full stop. Accordingly, no further adjudication is called for in the matter. As full stop. No further adjudication is called for. Accordingly, the petition stands dismissed for non-prosecution because nobody is here. So we marry Zaba more correctly.
39.
Yes. Where is that report?
No, no, the PWD, my lord.
Who is appearing for PWD?
Because it is, he is
Huh?
for PWD.
Get hold of Mr. Whoever is appearing for PWD. Bring him.
41.
Yes. Who is appearing for the respondents? What more details do you want? Why are you not releasing him the money?
So in fact, this was introduced that point of time for the court. That has been approved and finally that has been rescinded.
But whoever had died prior to that, they will also not get. That rescission is after the COVID period, COVID had waned.
Yeah.
But who have died before that, there are reports in his favor. Why is the money not being released?
Really,
And why you have not filed a 50 lakhs is involved? State is not bothered. Why an affidavit is not filed?
finally on 37/2022.
I know, I have seen that,
Yes.
that you have withdrawn that scheme, but that will not have a retrospective effect. It will have a prospective effect. Whoever are covered by this scheme will have to be paid.
In fact, notification filed.
He was not paid because there was some error in his name.
Hmm.
Recorded in the death certificate, death records, and as well as the treatment records. That was also corrected.
That was correct.
And he died in 21, peak time, October, May, peak. And this withdrawal occasioned only in July. Right?
13,
13/7/2000. Yes, Mr. Ajayika, what is your instruction? Huh?
As per our instruction, Lordship, that notification has been, not valid, Lordship, now, because it has been withdrawn on 13/7/2023, Lordship.
So no, is it also given retrospective effect?
It has been rescinded from that day.
That day, whatever has happened before that, they are entitled. Who is the person should release this amount? Director? Yes, madam.
Finally, direct the petitioner to impede the DME, Director of
Who? Director?
Education. He is the main person.
Why?
Here's the.
He's not a
documents,
officer, he's a group.
I think the documents are with the DME, Lordship. Instruction has not yet come, Lordship.
What was he? What was he? What were you working as?
He is not a doctor.
Chief Medical and Health Officer. Director of Health Services is there. Why should the Director of Medical Education come in? Why should the Director of Medical Education come in? He's a group, he's a health A.
Will be given by me, Lordship.
Where? Show me.
It is not here.
We'll ask the Director of Health Services to appear before this court and let him explain why this money has not been released. There is number of notifications, number of reports in his favor. And the family is not being paid. COVID variant. And this man was the in charge there. He got COVID, he died. And you make all errors in his reports. Names are written wrongly. That takes another year to get corrected.
Lordship, may kindly see Annexure Z, Lordship.
Page,
Diagnosis, page number 26, Lordship. Diagnosis, COVID pneumonia, septic shock with T2D.
with COVID-19 positivity, death with comorbidities with positive COVID-19 positivity. Man does not die about COVID-19, he dies about because of the comorbidities.
The diet, COVID, Lordship.
He died with COVID, madam. There is certificate.
What is the record?
COVID audit was done. He was found. You come to page 29. This is your joint health director. Come to page 29.
Lordship, may kindly the time, Lordship.
Come to page 29. You have time from 23.
No, Lordship.
Come to
that-
page 29, madam. I'll just satisfy your
Yes, yes.
query. I'm forwarding a certificate, so and so,
Copy
who
of-
died on so and so due to COVID. He only died in that institution.
that
Now tell me,
record-
when are you telling me when you will, you give me a date when you will tell me when you will release this money. On the next date, you will have to tell me that within this time, we will release this money. Or your director will be here at 2 p.m. We can't permit this to happen. And you come further certificate, page 30,
One, Lordship.
this week itself.
Lordship.
This week itself. The respondents collectively are required to apprise this court on the next date fix. The time frame within which the petitioner would be released petitioner would be released the dues on account of death of their husband oblique father on account of COVID related ailments while working as a frontline COVID worker. Also, list this matter again on 7/6/2024. On 7th, you will have to give me the time frame that within 1 month, 2 months, 5 years, 10 years, whatever it is, that we will release the money. 50 lakhs to the petition, that much. Only. And if you don't have that, your concerned authority, let him be here.
Item 42.
Lordship. There are three affidavits which have been filed by the respondent. One affidavit NHI has filed, which is most important. Is only they have filed on 21/5/2000.
NHA has filed an affidavit here.
Yes, filed an affidavit.
We filed, we are for Reliance Jio.
Ah.
So we filed the vacating application.
Your case is 4.6.3.
Yes,
That is permissible.
yes, that's permissible. That's.
So my lord, I have to file a reply. So for NHI is concerned.
Where is that NHA affidavit?
Yes. NHI affidavit.
have filed on 21.
What NHI has got to do with this?
Yes, the permission has to be granted by NHI.
That
So
they will
NHI
grant, that is an administrative
No,
action, Mr. Ras.
my lord, then I have to file a reply to this file. I'll give a, I will argue this matter, my lord. There are two, three cases we have filed, similar order. has
See,
been filed
there
by this
are
court.
matters here wherein you appeared for the other side also.
I'm sorry,
You appeared for the other side also.
other side I don't remember, my lord.
There is,
I don't
at
know
least my research brought out one or two matters.
the Other side.
Wherein
I don't.
the
remember.
plea taken was that the fact, it was not factored in. That one, I think you were there, one
Brick industry.
writ last year, day before, year before. I'll give you, I just somehow missed out.
I just give a reply, my lord. and
You
I
give a
don't know,
reply,
Chief,
when?
In 2 weeks' time, I give 3 affidavit has been filed.
10 days.
10.
I will forget.
10 days, 10 days.
Yes, Mr. Roy.
Yes, my lord, okay, but let the date be fixed and it should be heard by law, only my anxiety is this. And the petrol pump.
My experience is when Mr. Das says that he will argue a matter on that day, invariably he will argue
That's right.
till now.
Right.
So don't worry about that.
My lord, let it be on
18th,
17th, my lord.
17th, we are not coming.
17 years to come alone.
He will come alone. Or if you sponsor, we can come.
18th, my lord,
18th.
18th.
On Mr. D. Das, Leonard Senior Counsel, appearing for the petitioners, submits that Ms. S. Sharma,
Yeah.
counsel assisting Mr. D. Das, Leonard Senior Counsel, appearing for the petitioner, submits that the petitioner be given 2 weeks' time to bring on record the rejoinders to the affidavits filed in the matter by the respondents. Also, Mr. J. Roy, Learned Counsel, Senior Counsel, appearing for the respondent number 5 and 6,
I'm appearing on behalf.
and Mr. C. Burwa, Learned Counsel, appearing for the respondent number 8. 3, you're for 3. 3. Respondent number 3 submits that the matter requires to be expeditiously heard. Full stop. Accordingly, while permitting the petitioner to bring on record the his rejoinder to the affidavits filed by the respondent, the same should invariably be done on or before 14/6/2024. Also, list this matter again for admission hearing on 20,
My lord,
206.
20 is better. 20.
20,
Yes.
206/20. So you have a week's time.
18, there is provision makes better. No teachers case are there, provision.
Okay, that's serious matter.
19, 20, the series.
But that will come in the stay vacating column, my lord, or?
No, it will come for admissions. There is no point in going for the
Yes.
stay vacating because that I will have to touch the merits.
Yes. There is an interim order that will come.
The interim order passed earlier to continue till the next date of this. Only now it's very narrow.
Yes,
He says 4.6.3. If 4.6.3, we can adjudicate the matter, that is the end of the
End
matter.
of matter, right.
And you will also have to show 2 things. Person aggrieved and that the guidelines can be enforced before this court.
That's a guideline is followed by, or there is a rule. On the basis of the rule, this, I'll show it. There's an
Because
act. on the basis-
And so far as I remember, those guidelines have been held to be not justiciable by this court.
No, then guidelines, my lord, that.
Guidelines, this very
No, these
guidelines,
Guidelines.
1 kilometer.
No, this guideline was not shown earlier that there is an act. In pursuance to the act, this rule has been framed. On the basis, yes. this
Petroleum
guideline Contains. in the-
That
in the
has
act.
not been gone.
Yes, that's what I have.
You will have to deal on that.
Yes, that's why. I'm deeply opposed.
43.
My name may be recorded, my lord. For respondent number 7, my lord.
Mr.
AHMR 20.
For respondent degree, right? Yes, Mr. Soikia, what are you waiting for?
Items 49 and 53.
Oh, those, Joymala.
43.
May please, my lord. My lord, the issue of this case has been reflected by this honorable court in its order dated 8/3/2020.
Now, tell me one thing.
My lord.
You have come here with regard to an order passed, allowing the departmental authority to take over,
Yes,
right? Now, your grievance in the earlier round of proceeding before this court was, you are not given an extension, right? That matter, this court was entertained. Then it was said to be infructuous and closed. Is your right not closed?
no, my lord.
Why? You are not extended. I know the act. I know the act. I know 9(3) also.
Yes.
But in the facts of this case, when the your prayer for extension was not entertained, how can you come by this in an indirect manner?
My lord, because if your lordship goes through the objective of the act. this act
I'm
does
not on the act.
contemplate a
I am an
situation-
order of this court. An order wherein you came saying that this thing must be extended. They say 1 year is over, but that is not the intent. 1 year they can,
Yes.
maximum 1 year. Now, once that this court has come to the conclusion that your right is extinguished, that order, have you seen that order?
Based on their submission that 1 year period is
No,
over.
when that
Prashant.
order is subsisting, how can I entertain a challenge to this order? This is consequential. May be wrong, but when that order holds the field, how can I entertain your challenge to 2012?
My lord, because what my submission is that after they had taken out a notification appointing that ad hoc chairman, my grievance arose then because the act does
That-
not contemplate
no,
the
no.
appointment of ad hoc chairman.
That is just an ad hoc arrangement.
Yes,
They have used the wrong word there, Chairman. It's not that. It's just an ad
my
hoc
submission is
arrangement.
that it could not have done it.
But how can you make a grievance when this court had already held that your right is extinguished?
That was based on their submission that my tenure, that extension of 1 year is over.
Mr. Bro, that extension, once it is their submission or your submission, it's a court order.
My lord.
Now, that holding the field, how can you may present a challenge to 2012?
Because my lord. it
You
is-
think over it, come back at 2. Think over it, come back at 2.
Orders item 44.
Why is it before me? I had released it.
Yes, my lord. There's a typographical perhaps error, my lord.
What's up?
Your lordship has released.
Mr. Ek, this matter has been listed before this court. However, on the last date of listing, that is on 16/5/24, this court had held that the matter to be not treated as parted anymore. However, it is found that the said portion of the order was not reflected in the ordership. So accordingly, the registry is directed to list this matter before the appropriate bench, and the matter be not treated as a parted matter by this court any further.
Obliged, my lord. Quickly, obliged.
45.
None appears for the petitioner. Who is appearing for the respondents?
I appear for government. Pleadings are completed here, sir.
You have agreed that some amount you are going to pay him. Pay him that much only.
Already, affidavit says that some amounts are remaining and.
Remaining that you pay.
Yes.
Okay. None appears for the petitioner, Mr. S. Borua, learned counsel, representing, learned government advocate,
Yes.
appearing for the respondents number 2 and 3. none has appeared for the respondent number 1. No, 1, 2, and 3. All the respondents. Full stop. Disposed of. Move DD.
46.
Substitution.
Yes, ma'am.
Heard Mr. Omar.
Chamber.
AJ Das, learned counsel for the petitioner, for the applicant.
Chamber.
So the instant interlocutory application has been instituted praying for substitution of the petitioner in WPC number 5268/2019 by his legal heirs who are applicants in the present proceedings. So the petitioner in WPC number 5268/2019 had expired on 16/12/2020 during the present pendency of the said proceedings. So the application is not objected to by the learned counsel appearing for the respondents. Accordingly, the prayer as made in the present interlocutory application is accepted, and the applicants herein are included as are substituted as petitioners in place of the original petitioner in WPC number 5268/2019 and would be numbered as 1 Roman 1, comma 1 Roman 2, 1 Roman 3, 1 Roman 4, and 1 Roman 5 respectively. So with the above directions, the interlocutory application stands disposed of. So in view of the orders passed today in IAC number 616/2021, the following legal heirs of the original petitioner are the original petitioner is substituted by his following legal heirs. I was to make Amburiba. A 1, 1, 1, 2, Bitunamas. A data. 2, 1, 1, 2. So, the petitioner is to file an amended cost title within 3 working days. The matter registry to list this matter again after the amended cost title is filed by the Mr. S. Bora, Mr. N. Bora, and Mr. R. Sharma, learned counsel appearing for their respective respondents are present. I list after the filing of the then we'll see.
47.
This case, lordship, the petitioner's case is that lordship, near to their residence, some government lands were there, your lordship. They are using a portion of that land for connecting the PWD road, lordship. These are the only ingress and egress of their path, lordship. And that was allotted in the name of House Bhavan. They have filed affidavit, lordship.
Also, the petitioner's claim is that they are using a particular plot of land, which is government class land, for ingress and egress. But finally, from the trace map, and it has been found out that that land has already been, that portion of land has been already allotted to the Hasib Musafi Khana, and that for that Hasib Musafi Khana. If at all, petitioner allotting that land will be frustrated. And the petitioner's claim is that they have been ingressing of 2.5 of the allotted land as an approach road. And this from the trace map and also from the report of the circular. Yes.
I'm not hearing you properly. Any report for me?
Our representations are pending before the deputy commissioner. If they can consider the case of the petitioner's lordship.
The affidavit has been filed in the matter by whom? There's an affidavit here.
Respondent number 3, 5. At 12/11/2021.
18/11.
Have you gone through this? No.
Yes, Lordship. I
This-
did not find any reply, Lordship. But it-
They say that if that your prayer is allowed, that allotment to the Hajj committee
Lordship.
would be
But
frustrated.
Lordship, there are entire 4 bighas of land. Our case is that if they construct on the western part, leaving the eastern. part,
That how can this court direct? This court cannot direct.
Representations are pending. If your Lordship direct that my representations may be considered or a speaking,
We'll say nothing.
and then speaking order may pass, Lordship. And they can dispose of the.
The answer is
Then,
before
then
the
I'll
board.
have to come to a conclusion.
Lordship.
Madam, that I cannot, because with this stipulation, how can I? Sitting in 2 to 6.
Entire 4 bigger land was allotted in favor of
That
the.
4 bigger land, whether they construct it in the western side, whether they do it in the eastern side,
That is
it's
the-
for the authorities and the Hajj committee, not for this court or you.
Then Lordship, in regard to this affidavit, I'll file my reply, Lordship.
On the prayer of Ms. R. Chaudhary, learned counsel for the petitioner. Lists this matter again on 13/6/2024. Within 13, you file it. We'll dispose it of. You show me how we can do it.
Lordship, can it be
Eh,
on 18 June, Lordship?
18/6.
Obliged, Lordship.
Mr. S. Burwal, learned counsel appearing for the respondents is present.
Obliged, Lordship.
48.
IAS and Burwal.
May I please, your Lordship?
That term is gone. None appears for the petitioner on call. Mr.
M. Alam.
M. Alam is for the respondent number 1. And Mr. S. Burwa for the state respondents. Also. As none has appeared on behalf of the petitioner on call, comma. This matter, the petition stands dismissed as being dismissed for non-prosecution. ISI about it. I disposal. 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 Yes, Mr.
In this case, Lordship, the state of Assam is the petitioner and our main grievance is against the government of Tamil Nadu.
49.
But there is a office note there.
That they
which
have
should-
not appeared.
No,
What?
which shows that the service on respond number 3, that is the PCC of Tamil Nadu, has not been affected. It cannot be affected because notices were issued only on 10/5. If I just re-verify that. Yes, Mr. Soikia. Notices were issued on 10/5 and the note of 29/5 says respondent number 3 not served.
Then
So
let
we'll
us-
wait for some more time.
Yes.
We'll wait for 10 days.
Yes.
One thing which I would just want to ask you for my input. Now, in pursuance to the orders of the Tripura High Court, a committee has been constituted, wherein also pertains to elephants.
That Lordship, I'll have to examine.
You will just,
examine.
that order, Ms. Borwa can give it to you.
Yes.
It
We'll
is,
examine that.
I'll just give you that order. Prerna Singh Brinda. Ms. Borwa, it's Prerna Singh Brinda.
Yes.
Just bring it to the notice of the Advocate
Yes.
General. Seen the office note, heard Mr. D. Soikia Lanet, Senior Counsel and Additional Advocate General Assam, appearing for the petitioner. Also heard Mr. DJ Das, Lanet
For
Counsel,
respondent
appearing for the
Respond number 8, your Lordship.
respond number 8. And Madam,
She's for respond number 8.
8, full stop. Seen the office note dated 29/5/2024, which reflects that the service of notice upon the respondent number 3 is not complete. So it is also noticed that the notices on respondent number 3 was issued only on 10/5/2024. Accordingly, the registry to list this matter again after 2 weeks, 3 weeks, 3 weeks, along with with a report regarding the status of service of notice upon the respondent number 3. So I'm not saying anything about this premising matter. You examine it. If that is done, we can always ask that body.
It is reflected in.
Let the AG have that. Let him examine that.
Yes, Lord.
Item 50.
List this matter again after 3 weeks question. You want a date, Mr. Soikia? No,
If the date is
Possible-
given, then let it be.
it will be better. When?
20, that will not be, or maybe 26.
20?
21st also, Lordship, maybe please.
First of,
21st,
21st.
yes.
No, 3 weeks would be 1, 2, 3, 24th.
Then immediately after opening, Lordship.
Opening. Okay. List this matter after 3 weeks.
16th of July,
As prayed for, list this matter again on 16th,
16th.
16/7/2024.
Lordship, it is not inconvenient, can it be before the vacation, Lordship? I understand.
I want it.
We'll
21st,
have to.
but
He wants it completed more than you. He is more pressure than you are. He wants it completed. We'll have it on 16th.
16th of July.
Highly of that.
Item 50.
Based on contempt application, Your Lordship, the order, Your Lordship, against alleging violation of which Your Lordship will pay starts from page, Your Lordship, 15 of
28, 29.
Lordship. 20/12/2022.
2012, 22. Yes, Mr. Bharat.
No, I filed my affidavit, Mona.
May kindly
Sound.
come to page 17.
70.
Page 17. Operative part of the direction.
Page?
Page 17. 1/7 of the contempt application.
Okay. In view of the aforesaid facts.
Both the writ petitions are disposed of by directing the NCGT to undertake a verification of that which should include the measurement of works done. It is needless to mention that such measurement have to be done in presence. So that no prejudice cause either party. The measurement have to be done in the manner. Therefore, it acts a comprehensive period of 2 months from 0 to 6. Such wherein the payment made explicitly as indicated above as no officer was involved. So then terminal itself not personally aware this decision for other works. Now, Your Lordship may kindly come to page 33 of their affidavit. It was, Your Lordship, in fact, Your Lordship, a tender process, pursuant to a tender process, we were allotted the work, Your Lordship. And ultimately, Your Lordship, while work was going on.
What was your work? Desiltation of.
Desiltation of.
How can this exercise be carried out?
Lordship, that's why, Your Lordship. Now, Your Lordship, it was their submission that but Your Lordship will kindly come to page 49. Our affidavit in reply.
So what is the final conclusion the GMC authorities have arrived at in the matter?
Right, that Your Lordship will kindly come to page 49. My reply, Your Lordship. In fact, they have measured it earlier, Your Lordship. Your Lordship, page 49. This is, Your Lordship, the letter written to us while terminating our contract, that it, as reported by the divisional engineer, approximately
Okay.
25 to
Okay.
30. So
Mr.
that
Bharat.
they can make this payment. Your
Okay,
Lordship.
fine. This submissions were made basing on, this order was passed basing on the submissions made by you.
Yes, but.
Maintainability, everything, but be that as it may. You-
Calculation cannot be done.
You take a final call in the matter, bring that on record. If it is satisfied, he will take into account all the aspects, even that letter of 21.
Lordship, that they
And
have
then-
already
then come
measured
to a
25
conclusion.
30%.
You can't keep them, either say that they are not entitled to even a penny, or they say that they are entitled to 10%, or 1 lakh,
Yes,
or 1
that-
crore.
That, what
You-
you say is another dog. What he is entitled to, the work he has undertaken till the date of termination, that we are ready to pay.
Yes. let
That
them
you come
pay
up, you pay that, we'll close it today.
that. Lordship.
You come up.
I am agreeable to that, if 25%.
Mr. It's between you and me now, contempt. You get me that order, that they have a terminated on so and so date. As per our estimate, this is the amount of work done. That is the end of the matter. And Mr. Bhattakur will always have a liberty to challenge that.
But I will not challenge-
Why are you keeping this matters pending?
I will not challenge if this 25-30% of the.
Whatever it is, they may not give you, they may say 10%. Rest is for you, but this contempt will not survive. When? Tomorrow, day after.
Let me after 5, I have to file an affidavit, my lord.
No, you need not. You just give me that order. Compliance order.
Orally, I have to only state, my lord. Orally, I have to state, my lord, that this is the.
You take a call, let your authority pass an order to that extent. How will his rights be crystallized otherwise?
First we'll fix it after 3 days, my lord.
3 days.
In the meantime.
Lords,
On the prayer of Mr. S. Borak, learned counsel, appearing for the respondents, who submits that a final decision in the matter would be arrived at by the authorities of GMC, and the same would be produced before this court on the next day. So, sir, accordingly, list this matter again on 10/6/2024, giving you enough time. Mr. Bhattakur, whatever they give you, take it, rest you make, otherwise what, siltation every year today now,
Lords,
it will be
that's
changed.
what you know. And that's why I am saying that the measurement they have made earlier, that will be the basis. We are ready to accept that.
That I'll not say anything.
Lords,
Whatever they do, if you have a grievance, we'll give you a liberty, that's all. But let these matters be resolved.
Lords.
Yes, next.
Item 51.
Yes.
Matter pertains to the quality of reports of two writ proceeding, my lord, in 1991, 1996. Thereafter also one in 2005 also there was a proceeding writ petition. What actually happened, my lord? There is a plot of land in respect of which the allotment was made to me. Now that was 2 times cancelled, interference was there, and there are multiple proceeding writ petitions were there, my lord. Now, what actually happened, I called for record of these 2 years writ petition, my lord, because I lost it. Because I was dealing with the matter, my chamber was shifted from ground floor to the first floor of my residence, my lord. Now, in the melee, these 2 records were lost. So last time when the matter came, the question arose there, why these are my writ petition, why should I code it? So I thought, I explained it by an affidavit, my lord.
Yes.
That these are lost like that.
Filed a
So it's a very simple matter, my lord.
clarified 2 things, my lord. First, they are having patta land in their name. 24 bigger in the
There's
same.
no objection from writing, my lord. It's still very simple matter.
And the second thing is that there is a pond there, village pond there. So settlement cannot be given to them. And
Now,
that-
what is with regard to these 2 records? 91, Civil Rule 91 and Civil Rule 96. WPC 2005. What are these writ petitions connecting to?
so
What
that
are
way-
these writ petitions related to?
These are, one is,
Civil Rule 3969/91.
1991, and the other one is 1433/1996. These 2 records are writ petition. And the prayer also.
that way taken into consideration in the impugn order. That is page 50.
The prayer, it is there, my lord.
So the order copies are before us. Copies of these orders are before us. Mr. Sharma, the orders copies are before us.
One is
7692.
3969 of 1991. The other one is 1433/1996.
These orders are before us. So we'll see, we'll have this, we'll hear the matter. Orders are before us.
Yes, madam.
So writ petitions, why bulky things do we call them? We'll keep it pending, we are not closing it, but we'll take up the matter for admission. Writ petition.
Court for, it will facilitate both the party ballot. Because there are certain orders, the report contains, the record contains, my lord,
We will only consider the
those are
orders
all-
of this court, which is already before us. And then we find that this is required, we will do the needful, Mr. Sharma. I'm not closing your eye. I'm keeping it. Now, when can I hear it? Today or when do you want it? This matter, when it can be taken up for final consideration. No point in keeping it pending. Thursday or Tuesday? When do you want it for final hearing? Final hearing.
These, my prayer is only to call for these two records only.
These records, if required, I'll call for it. There is no problem. But when will I take up this matter for hearing? Tell me. Convenient to you.
In the usual course of my lord, the office may say, usual course.
Huh? When? Shall I have it on 11th? 11/6. Will it be comfortable to you?
Then it will come for admission, my lord, thereafter.
For admission hearing and we'll close the matter. We'll hear the matter finally. And if the records are then required, I'll requisition. Don't worry. As agreed to by the parties, let's this matter again on 11/6/2024 for admission hearing, and endeavor would be made to dispose of the matter on that day. Endeavor would be made to dispose of the matter.
Much obliged.
52.
Service is complete.
It's completed, and on last occasion, junior government advocate submitted that he is supposed to file an affidavit.
That they want to file, they'll file.
Yes.
Seen the office note dated 27/5/2024, which indicates that the service of notice upon the respond number 8 is complete. Accordingly, registry is directed to list this matter. You have not filed a,
We have
you
not
have
yet filed
implemented,
affidavit in reply.
no, you have not filed an amended cost title, bringing in those two persons who have been now implemented. 7 and 8,
And 9 also.
9 also.
9. He has not served an extra copy on 9.
Lordship, I will have to take the instructions regarding that matter. Actually,
Ekun alage. List this matter again on Wednesday. Get your instructions.
Lordship,
Wednesday, very well. List it again on Wednesday. Get your complete instructions on that.
obvious, Lordship.
53.
In this case, for the first time, I'm appearing for respondent number 1. We are going to file an short affidavit, Lordship. 1 week's time may be given.
No, I'll have to extend it further, Mr. Swagia, because I find that respondent number 5. There was a note here, respond number 5.
Don't worry.
Respond number 3, sorry. Respond number 3. Now you are for 1, there is
I
no
am for
problem.
1, Anurag Jain, Lordship.
Respond number 3 delivered unserved. It has been returned back. Who is respond number 3?
I'll take, I'm allowed to take fresh steps.
First steps.
And Lordship, I would like to file an amendment petition.
He has almost made a cricket team, Lordship.
Hmm?
9, including 2 more today.
I am 9.
So-
I am 9, my lord. I was not made parties.
It is seen from the office note, there, Mr. S.P. Roy, learned counsel for the petitioner, and also Mr. D. Saika, learned advocate general appearing for,
Lordship is senior advocate.
senior advocate appearing for the respond number 1. Also, it is seen from the office note dated 31/5/2024 that the service of notice, that the that the notice sent to respond number 3 has been returned with the observation, apostrophe ligiba, no such addressee return to no such addressee, full stop, RTS, apostrophe close to area, full stop. Mr. S.P. Lanak, Senior Lanak Counsel, appearing for the petitioner, submits that he would take fresh steps for service of notice upon the respondent number 3. Full stop. Accordingly, steps be taken for within 3 working days from today, raising to list this matter again after 4 weeks. In the meantime, the respondents already served are at liberty to bring on record their stand by way of filing affidavits.
Highly obliged.
54.
My lord, as per the last order, which was
Hmm.
passed on 3rd of April, my lord, there was a direction to the respondent number 3 to, my lord, release the pension after we give our phone numbers and WhatsApp email. And into that effect, we have filed an affidavit. We have communicated the letter on 2024, and it was received by them on 26/4. And now almost 6 weeks have passed, but they have not complied with the directions of this honorable court, my lord. This is willful disobedience and deliberate negligence to implement the order, my lord. And no instruction, nothing is coming forward. My lord, I have already communicated to the department, my lord. So whatever has to that effect, my lord, I'll need some time to get the instruction, my lord, whether it has been complied with or
How
not.
much?
2 weeks, my lord, that will be.
Just a telephonic call.
That is the problem. It's from Delhi. I do not have the number. I'm communicating through email. I have already communicated through email.
Or if you don't get it, you try once more, come back next time, we will call them, they'll come immediately. They'll come immediately.
Perhaps they need an invitation.
You should see the background of the person.
My lord, I understand, my lord.
You have awarded him. And now why do you treat him like this? If he is having something misrepresentation, that, come and tell this court, we will take necessary action. Mr. Pegu, I'm giving one, not your respondent, to Pegu I'm giving.
My lord,
How many? We'll have it on 19th.
19th.
19th?
My lord.
On the prayer made by Mr. G. Pegu, Lanak Counsel, representing the respondent number
1, 3, and 4.
1, 3, and 4. List this matters again on 19. List this matter again on 19/6/2024. So by the next date fixed, if the instructions are not furnished to Mr. Pegu, necessary orders requiring the personal appearance of the said respondents would be ordered in the matter.
I am for respondent of 5 and 6.
5 and 6. Madam, you are for? KK, Mr. KK Nandi, Lanak Counsel, appears for respondent number 5 and 6. And Madam? Huh? Yes, Jasmine. Yasmin. Yes, Yasmin, Lanak Counsel, appears for respondent number 7. Will say.
Obliged.
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 Yeah, sir. Hearing as a timing matters, sir. It's equally disposed to
Or there is no provision.
Have you incorporated that in your written?
That ground I have taken, my lord. That
No, have you incorporated that in your written argument?
not in so much detail,
Give me a piece of paper, just incorporate that and give it to me.
but I have taken that ground
Ah.
that he cannot be a judge. as well
No,
as
just for
prosecutor.
my reference.
What I am saying is that, my lord, I am relying on a judgment
Oh.
of this honorable court division bench judgment, wherein it has been held that even if rule doesn't provide for appointment of presenting officer, they have to appoint, because the inquiry officer cannot assume the role of a judge as well as prosecutor. I have given in the judgments, my lord, I have given that.
Have you indicated that in your written argument also?
No, my lord. Or
Then
I'll put in the. in that-
Just put one line, one page thing and just give it to him.
Fine, ma'am, fine.
Just add that,
Yes, ma'am.
so that I'll not forget it.
Yes, yes. Deeply obliged.
Matter fixed at 2 p.m. Item 32.
30.
May I have any problems?
Yeah, Get hold of the standing council. PNRD.
43. Item 43.
Yes, what have you got?
My lord, when I had perused the interim prayer that I had made, my lord, the prayer was not for seeking an extension. My prayer was to only continue holding the post of chairman. So that essentially meant status quo. That did not amount to extension. And my lord,
No,
even in the
I'm not on
request
that.
of the-
I'm not on that.
My lord, even on the in the honorable court's order, the honorable court had proceeded on a belief that the honorable court
Mr. Bhuva, that whether it has been wrongly produced, wrongly proceeded,
my lord, there's a clear
Oh.
distinction between status quo and extension, my lord. Status quo is that the direction
no,
was
no, no,
given
no,
that
no, no.
maintain your ground.
Mr. N.J. Gogoi learned so-and-so appearing under submits that the tenure as well as extent term is already over.
Yes,
And as such, nothing survives in the instant.
yes.
Taking into account the so-and-so as infructuous. Until and unless this order does not go, how can we further consider your case?
So,
Because this has given a seal of approval. And see, their statement is that we did nothing in the matter. We had appointed somebody, we withdrew it,
yes,
and then we waited.
Yes.
Once this order dated 17/11/23 was passed,
Yes.
then we issued the order dated 20/12/23.
Yes.
Now, whether to examine the validity of this order, I cannot ignore this, wherein your continuation, your writ petition, earlier writ petition was that you should be allowed to continue.
my lord, the order was for status quo. The court directed that both the parties will hold ground, and since I was already continuing in office, I was allowed to continue.
I'm not
Till
on
that
that.
time, they were considering my
That
application.
that order of status quo was given because you had raised a plea
Yes,
that under 9A, the election authority is not been appointed. Two, there is no limit under the regulation for extension.
under 9C. That is
So,
primarily the grounds.
so this court said, okay, status quo.
Yes,
Now this observation that nothing remains.
my lord, that is only so far the status quo order was
No,
concerned.
no,
that was
no, no,
defeated.
no. It is with regard to your whole prayer for extension.
My lord, that was the submission on part of the learned standing.
Be that as
council.
it may, it has now converted into an order.
That was based on an erroneous understanding, my lord. That was not
That,
ground.
Mr. Burwa, you don't understand. This is an order. This is binding on me.
But
It
thereafter,
might be few lines, but that is binding. Now, how can I go beyond that?
thereafter the matter has been admitted and substantially heard by this court.
This
In
one,
fact, an interim order was passed on the last occasion, order dated 22/4/2024. My lord, the matter.
21?
The instant matter has been admitted and hearing was.
Where,
done.
where?
My lord will peruse the order dated 22/4/2024.
22/4.
Yes, on that occasion, the honorable court had the occasion to consider my interim prayer. And the honorable court proceeded on the belief.
It is here insofar as the prayer for interim relief is concerned.
Yes,
Court is of the considered view that as the normal tenure of so-and-so,
yes,
the prayer for the petitioner being cannot be further extended
yes,
into allow the so-and-so is refused.
yes.
Then
So, my lord, the court proceeded on the belief that there was in fact an extension by judicial order.
Mr. Boa, these two orders, have you filed any steps? Have you taken steps to annul these orders?
No, my
Then
lord. My lord, this was so far the interim order was concerned on the last. it
be
does
that
not-
as it may,
My lord, that,
if you cannot continue, what is the point in making a challenge to this 2012? Even if I set it aside, what benefit will it come to you? Nothing. I can't extend your services now. Two orders, one in the earlier proceeding, another here.
this was only for, so far the interim order was concerned. Even my lord, if I do not press the second prayer so far, might extension be
Now
considered.
today, if I have to allow your petition, what relief can I give you?
My lord,
What relief are you claiming?
my lord will perhaps consider the validity of the notification that they had issued.
Okay,
by appointing the ad hoc
I
chairman.
hold that it is bad.
My lord.
I'll interfere with that.
Yes.
Then what?
So, my lord, the natural corollary of that would be that the steps under section 9 clause C will have to be naturally resorted to. Because there's no other way that the act contemplates that
Because you are no
management
longer
of-
there, this court, you are no longer existing. How can I again exist somebody or extend somebody who no longer exists? You're already finished.
If that is the case, then my lord will order that that this notification is set aside and the competent authority will hold the elections within a stipulated amount of time so that I can participate again.
We are taking steps for conducting the election, Lordship.
When are you holding it? When are you issuing that 9A notification?
Lordship, after the general elections are.
Day after tomorrow, get me that instruction.
Yes, yes, Lordship. We are writing to the districts.
We'll not
Lordship,
interfere with this,
yes.
but he is right. This body, in terms of that regulation,
Lordship,
act, you will have to.
Lordship, the commissioner secretary is writing to all the districts, Lordship. We have to hold the elections in all the districts.
I only want when you are holding it.
For Lordship, next week, Lordship.
My lord, may I kindly
week's
draw
time,
the Lordship's
Lordship.
attention
For a
to
week's
the
time.
order dated 18/3/2024. This order was already passed by this honorable court, directing them to file an additional affidavit stating with the time limit within which they will hold the election. They have filed an additional affidavit, my lord, where they have not given us any time.
There is nothing.
My lord,
Till 20.
I know that.
yes. So, my lord, perhaps they have to come up with a stipulated timeline because if my lord looks at regulation 9 capital A, the days that will have to be taken at each stage of the election has been clearly enumerated. So they cannot. be more
Heard
than those
Mr.
times.
A. Borwa. Also heard Ms. M.S.R. Bora, Learned Council appearing, Learned Standing Council Agriculture Department, and also Mr. Gogoi. You are appearing for?
4 and 6.
Mr. N.J. Gogoi, Learned Council appearing for the respondents number 4 and 6. Also, on the next date fixed, Ms. R. Bora shall apprise this court. On the next date fixed, the Secretary, Agriculture Department shall apprise this court as to the time frame within which the elections for
Lanka Regulated Market Committee.
this is
Lanka Regulated Market Committee.
Lanka Regulatory
Regulated Market Committee.
Regulated Market Committee shall be held. Full stop. In the event the said instructions are not forthcoming, this court would require the presence of the competent authority before this court. Full stop. Accordingly, list this matter again.
My lord may perhaps indicate in conformity with Rule 9 capital A.
That they know. Do you think they don't know that?
My lord, they do.
But we can do nothing for you. And this order also I'll not interfere, but I'll fix that time frame
I'm obliged, man.
on 11/6/2024.
I'm so obliged, my lord.
32.
Yes,
My lord, I have got only the standing committee's resolution by which the NIT was issued, my lord, but for instruction.
Hmm?
Friday, my lord. I'll place the written instruction, my lord. This is the resolution of the standing committee, my lord. By my lord. And petitioners claim, my lord, that he has that was petition order was.
My lord, as per instruction, no NIT, no NIT was issued.
The
Understand number 6 and 7 occupy the room. my lord. No fresh NIT.
now who is operating that room now?
Respond number 5, respond number 6 and 7.
They are operating that room.
Yes, sir.
How?
official, executive officer, 6.
Oh, 6 and 7. Okay. No, there were private respondents,
7 and 8, my lord.
7 and 8.
Yes, sir.
So 7 and 8 is operating that
No,
room,
occupying the room.
occupying the room. Sure.
Sure.
How?
Friday.
Mr. S. Dr. Learned Standing Council PNRD Department shall invariably apprise this court as regards the status of occupation of the rooms in Medhortari Market Shed
Medatari market.
under Jamadhat
Jamadahat Anshalik Panchayat.
Anshalik Panchayat, Sirakuti, Dhubri. Full stop. Mr. Dr. shall also apprise this court as to why the tender process so initiated in the matter for settlement of rooms in the said market complex was cancelled as alleged by the petitioner herein. Full stop. List this matter again on 7/6/2024.
Obliged.
Item 55.
May it please your lordship. Lordship, this IA has been filed seeking correction of two typographical errors that is kept in page 17, your lordship. Before that, lordship will take up page 8, para 2. Paragraph 7,
Para?
para 2, your lordship.
Para
Page-
2.
Yes, page 8, my submission. Page 8, para 2. And the relevant portion is at page 17 of the order.
Only this much.
Yes, sir.
Thank God. Para 7.
17 is because primary directions are on this date.
What is notable is that they were only appointed in the year 1999.
1981 has to be 1989. 1908-2009 has to be 22-12-2009. And 1908-1989 has to be 1908-09.
No termination order.
Page 26, everything has been correctly given, but the middle part, something was.
So this page 17 is the problem.
Yes, yes. 91 has to be 1989, year 1981.
1908-2009, the order dated 1908-2009 should be read as
22-12,
22-12-2009.
2009. And
At best. would be an
1908
order, way back in the year 1991 would be 1999.
yes, 1991 has to
Approved
be
by an order dated 1908-29, right?
yes, 1908-1999 has to be 1908-09.
This is 1908-09 is correct?
This,
You read that order. You read it in the correct manner. The order dated 22-12-2009 at best would be an order which has the effect of validating the appointments affected in case of the petitioners way back in the year 19. From the very select list which was approved by order dated 1908-2009. Is it correct?
this has to be 22-12-2009.
22-12.
Yes. Then I read it slowly, Lordship, after that.
Accordingly.
The petitioners have to be deemed in regular service with effect from 1908-1999. This stands correct. This is no alteration is required. And the order is at 1908-1999. This has to be changed to 1908-09.
1908?
2009.
1908?
2009, Lordship. 1908-2009 has to be understood to be an order validating the appointment of the petitioners effected in the year 1989 from the select list dated 27-10-19.
This is correct?
Yes.
So it is 1908-99 in the first line. It will be 22-12-2009.
2009.
9.
Yes.
91 in the third line would be 99.
1908-2009.
No,
And-
19-1.
Oh, yes, yes, yes.
99. And 1908-2009 would be 22-12-2009. Right?
Yes. And on the fourth line, this,
Accordingly, the petitions have to be deemed to be in regular service with effect and the order dated 1908-2009.
yes,
Right?
yes,
Has to be understood to be an order validating the appointments from the select list. Rest is correct?
it has been rightly reflected in the directions, page 26.
This is an old order.
It was filed early, but.
Also, heard Mr.
Okay.
K. M. Mohan, learned counsel for the applicant. And also Mr.
G. Pegu,
G. Pegu, learned standing counsel, Elementary Education Department, appearing for the respondents. The present interlocutory application has been so instituted, praying for correction of typographical errors which have crept into the order dated 15-12-2023. Also, the petitioner has submitted that the typographical errors have occasion in paragraph 7 of the said order, said judgment and order dated 15-12-2023, and therefore prays for correction of the same. Also, I've heard the learned counsel for the parties and also peruse the material available on record. So it is seen that a typographical error has admittedly occasioned in paragraph 7 with regard to the dates as mentioned therein. Full stop. For better clarity, the said paragraph with the corrections made is now recorded as below. Para 7, A to A, huh? A to A. Oh, A to Majot line issue, Tarupora 22/12/2009, A to 99, 22/12/2009, Aru A to about tomorrow 19. 2009, huh? A to minus, full stop. The above corrected paragraph 7 would now also form part of the said order dated 15/12/2003. No, full stop. Accordingly, para 7 as existing in the or judgment and order dated 15/12/2023 shall be now. Report television. Na quote kora agoda. Full stop. And the same is to be rectified, to be corrected. Full stop. Accordingly, para 7 as existing in the order dated 15/12/2023 shall now be read as follows. Follows quote. Huh? Full stop. This order would also form a part of the judgment and order dated 15/12/2023 and would be and should be construed together for and be construed together. So for all intent and purpose. So with the above observations and direction, the interlocutory application stands disposed of.
Deeply obliged.
Sorry, it happens sometimes, can't help it.
56.
Yeah, please, your lordship.
Then I'm the writ petitioner. My learned senior friend has filed an I. Allow it. We have no objection.
Been filed seeking impleadment of the applicants. This application has been filed seeking impleadment of the applicants being the co-owners of the subject matter in question.
Will allow it? Yes, madam, your name?
Be right.
V, right? V.
Be, yes.
V, right?
B or B?
Victor, she is Victor.
Oh, Victor.
Ah.
Yes, yes.
Heard Miss B. Right, Learned Counsel for the applicants and also heard Mr. H. Samuha, Learned Counsel representing the opposite party number. Opposite party number?
My lord, I'm resting. Opposite.
Parties number 1, 2, 3, and 4.
Sir. Page 4, serial number 1, 2, 3, then next page 4, 5.
Those are the applicants.
We implemented as respondent 8, 9, 10, 11, and.
Who are you representing in the opposite parties number 1, 2, 3, and 4?
I'm the.
That's it. They are the
Yes,
writ
they are.
petitioners, madam. Opposite parties number 1 to 4, oblique, writ petitioners. Also heard, anybody appearing? So and so for the, you are appearing for, you are not even made a party yet.
Yes, yes. We are not-
Sit down.
Sit down.
Also, the applicants in the present proceedings have contended that they are the co-owners along with the respondent number 5 in the writ petition of of a plot of land over which the shops, more particularly the shops as existing in apostrophe Kotari Supermarket. Kotari Supermarket, full stop. The petitioners have submitted that they are necessary parties and in the event any order adverse orders is passed in the connected writ petition without hearing them, their rights would be seriously prejudiced. Full stop. Mr. A. Chamuha submits that he has no objection in this court allowing the applicants hearing to implead themselves as the respondents number 8, 9, 10, 11, and 12 in the connected writ petition. Full stop. In view of the above position, the present interlocutory application is allowed. The applicants are allowed, in view of the above position, the applicants hearing are allowed to implead themselves as respondents number 8, 9, 10, 11, and 12 in the connected writ petition, that is WPC number 21 of 2024. So accordingly, the present interlocutory application stands disposed of. Full stop. In view of the order passed today in ISC 1527/2024, Namgita Likiriba are hereby impleaded as respondents number
8 to 12.
8, 9, 10, 11, and 12. Full stop. The petitioner to submit a amended cost title in the matter within a period of 3 days, 3 working days from today. Full stop. Don't want extra copies?
They have.
No, they don't have. You'll have to give them 5, 6 copies. Yes, Mr. Roy, that is the rule. Oh, you have to give them.
Deeply obliged.
57.
List this matters again after. When do you want these matters, Mr. Roy? Madam, when do you want these matters? Oh, he is enjoying. When?
Related matter.
Ah.
So, on 14. So this will be fixed.
14th, list this matter again, as prayed for by the parties, list this matter again on 14/6/2020.
May I please, Lordship? I'm appearing on behalf of SC Biswas.
Hmm.
Kindly 2 weeks time may be granted to file objection, Lordship, in IA.
Table matter mutak क्यों है ये रे?
Because of now, my lord, registry is my lord listing before the concerned bench, my lord, for stay vacant petition.
My stay, this court stay. Where is that impugned order? Huh?
Page 23.
But this is not the rule.
No, my lord. But the registry is not listing in another bench.
ये तो कोटी बसने पर matter क्यों है इसे मुtak? हाँ?
Interim order was conditional, my lord, page 25.
It was conditional. Who is now holding the charge?
The petitioner is holding, my lord. We have
You are holding.
the respondent. I'm the respondent,
You are the opposite party here.
opposite party. Bank details has already been sent in 23rd of March.
Okay. Madam, your name?
KLR Yanthan.
Just write it down. Miss so-and-so learned counsel submits that, the counsel appearing for the you are the applicant here.
I am the applicant.
They are the writ petitioner.
They are the writ.
So petitioner is continuing.
No,
You are continuing. You were appointed before that.
Lord, before the interim order and join also, my lord.
Appearing for The respondent number one, opposite party number one
In IA,
in the IA, oblique writ petitioner, prays that she be granted. How many days?
2 weeks.
No,
Lordship.
1 week. 2263 will come in, 1 week time to bring file her objections in the matter, in the present interlocutory application. Full stop. Prayer accepted. List again on, list this matter again after a week. Full stop. Mr. R. Ali, learned counsel for the application.
Lordship, interim order is there in this.
Continue. So and so is present. Full stop. Interim orders passed earlier. A writ petition of query. Heard Mr. So and so, and also Mr. R. Ali, learned counsel for the respondent number
6, madam.
6. Full stop. List this matter again after a week. Full stop. Interim order to continue till the next date of listing.
You keep the date, madam. 1 week date.
List this matter again on 14/6/2024. 14/6.
58.
Yeah, please.
60th. The, these are government works and there's a provision to go for this kind of extraction permission under the rules.
Yes, what do you have to say?
Lord. So far as the extension is concerned, my lord, but in this case, Lord, the extension was in respect of a.
Where is your affidavit here?
This is the third time perhaps.
They have not-
Geology have to answer, my lord. So this this has been given by the. Lot 72. my lord.
Huh?
Page 72. my lord.
Page
70.
70.
72.
7? There is some sound problem today.
Oh. A little find there's a government section of road. So it was a. And then for this kind of extraction if government desires in the interest of public knowledge. And my lords, the Water Resource Department should match a party because on their demand only. Affidavit is asked. Second quotum. Hey. My instructions are awaited from the Water Resource because they were the agency which has asked for extraction of this.
Now, who is appearing for the Director of Geology and Mining? You come to page 70.
Lordship.
This is the order by which you permitted. BN, you are BN Enterprises?
Yes, my lord.
Now you come to that page 71, construction of road embankment on B Dyke from Jorsey Mill to Nagarber, right? Now this was, then you had issued the impugn order, page 87. Right?
Lordship.
Now you come to page 88. Here it is Jorsey Mill to Nagarbera. Now you come here. Construction of second last paragraph. Construction of road cum embankment on B Dyke from Kasardia Pothar to Nagarbera. What is this?
Yes, my lord. That is our case. The mining plan permit plan, my lord, this is the same. It was initially approved for the my lord road, my lord, in respect of Nagarbera to Jorsey. Subsequently, based on the same permit area, my lord, they passed this order and then diverted the place from one village to another place without a fresh mining plan and permit.
You have your instructions. We'll have it on Monday,
Next Monday.
Tuesday, no, Wednesday. On the prayer of Mr. So Learned, standing counsel or government advocate?
Government advocate.
Government advocate appearing for the Director of Geology and Mining shall receive his instruction as to the shall receive instructions towards justifying the issuance of the impugned order. The order impugned in the present proceedings. List this matter again on 12/6/2024.
That may kindly be continued. Interim order was passed.
Interim order passed earlier to continue till the next date of listing.
I'm obliged.
Just get that clarification.
Lot.
Water resources, what will they do? They have nothing to do here. It is you who is the problem creator and facilitated by him.
Obliged.
Yeah. Timing it. It does.
Time being 16. Time being 16.
No. None has appeared for the petitioner even on second call. It is seen that on the last date of listing, that is on 7/1/2021, also there was no representation on behalf of the petitioner. Full stop. In view of the above position, the present writ petition stands dismissed for non-prosecution.
36.
Yes.
Allowed to do it. liberty to
Ah,
file a
right decision. Mr. M. Hussain Learned Counsel for the petitioner in view of the submits on instructions that he be permitted to withdraw the present writ petition with liberty to refile the same if the occasion so arises. Full stop. Accordingly, the writ petition stands dismissed with liberty as prayed for.
Obliged.
39.
Yes. Yes, Mr. Chaudhary. Where is your report?
Lordship, on 8th of December, a report was given.
That is not a report, that is a paravise.
Lordship, that was. Lordship,
Nothing is here, nothing can be made out from you.
Lordship, we do not, the PWD do not have jurisdiction over the hilly side. Till.
You are not making a road there.
Not, till the area where the PWD has jurisdiction, it's intact.
No problem. Then your only grievance is that that road is not being made.
Allegation is against the private respondents, madam. They have.
I got it. That you go before the civil court. Why are you here?
Lordship will give us some time, madam. We'll have.
Why? You are having time? Your case, whole case is that the PWD road is not being made because of the unauthorized construction by the private respondents. Now the PWD comes and says, we have done it. Till where we have to do, we have done it. Rest is neither our headache nor theirs. If you have anything, go before the civil court.
So we'll have it on Thursday. We'll have some instruction from the client, my lord. There are some.
Tomorrow.
My lord, they are.
Budba, Wednesday. It by slip put as prayed for by the as prayed for by the petitioner, list this matter again on Wednesday. Try to deliver. 5/6.
Okay.
And if you have nothing, withdraw it. If I have to come, we have to come in, we'll impose cost. Because once they say this, you have no case.
Hearing item 59.
Yes, Mr. Patori.
Right, Mr. Lord.
What is left here?
My lord, initially we have finished the violation of section.
No,
53.
your thing is that you are the government's action in taking out one commodity out of the market. That is what you are
Yes.
challenging.
Yes, we are challenging because that affected our salary problem. Now
Fine.
I thought that.
Nothing like it. They have affected your salary. Now, when will this quote come in? One, that the action is without jurisdiction. That issue is gone.
Gone.
Now you show me materials that these products should have been there and no other place.
But on 31st, they filed an affidavit where, my lord, they brought on record a promulgation which totally prohibits levying of cess, my lord. So in view of that, my lord, perhaps, my lord, we have to challenge this promulgation.
Where is that? Where is that? Where is that? I
On
missed out.
31st of May, they filed an affidavit.
30th of May,
I received. a-
85.
It is not on record, Lordship. We have filed the affidavit,
Give me a copy.
Lordship.
So in view of this, lordship may close the petition and grant us liberty to.
Because once that challenge goes, the jurisdiction question we cannot go into.
Yes.
Annexure A, Lordship. There is an ordinance of promulgation.
Para 3, lordship, with page 94.
Page
94, para 3.
94. So then in addition to the like, the farmers produce trade so and so and so audience, the department has issued letters to so and so. This is not here, why?
Filed it on the 29th of May, Lordship. The affidavit, Lordship. It's not on record, Lordship. We have filed on the 29th of May, Lordship.
Okay. So
The main,
goods remaining, not remaining, everything gone now.
everything.
So you're withdrawing it in light to
Yes,
file
my lord.
challenge to this.
Lordship may close the petition, I will done with liberty, my lord.
Mr. J. Patwari, Learned Counsel, appearing for the, heard Mr. J. Patwari, Learned Counsel, appearing for the petition, and also Mr. R. Bora, Miss R. Bora, Learned, MS R. Bora, Learned Counsel, Standing Counsel, Agriculture Department, and also Mr. N. M. Gogoi. You are paying for?
Three, four.
For respondents number 3 and 4. First up, Mr. J. Patwari, Learned Counsel, appearing for the petitioner, Mr. J. Patwari, Learned Counsel for the petitioner has submitted that the respondent number 2 herein has filed an affidavit and therein has brought on record a communication dated 15/6/2020, wherein a reference has been made to the to an ordinance, namely apostrophe, the Farmers Produce Trade and Commerce bracketed promotion and facilitation bracket over Ordinance 2020 issued by the Government of India. Also, in pursuance to the said ordinance being issued, the Secretary to the Government of Assam, via the communication dated 15/6/2020 has required the jurisdictional deputy commissioners to ensure that no market fee or cess or levy by whatever name called, under any state APMC Act or any other state law, shall be levied on any farmer or trader or electronic trading and transaction platform for trade and commerce in scheduled farmers produced in a trade area. Also, in view of the said position, Mr. Patwari submits that the said ordinance as well as the communication with the 15/6/2020 would now be required to be challenged, and accordingly prays that the present writ petition be permitted to be withdrawn with liberty to challenge the said ordinance as well as the communication dated 15/6/2020. Prayer accepted, the writ petition stands dismissed on withdrawal. However, liberty is reserved to the petitioners to file appropriate applications, if so advised, to present a challenge to the above noted ordinance as well as the communication dated 15/6/2020.
Deeply obliged.
Obliged.
Highly.
Will go?